Management and Administration Committee to order on Wednesday, April 14th. And let's start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we have a roll call, please, Linda.
Commissioner Inman?
Here.
Friend? Here. Stepka?
Here.
Richardson?
Here.
Thomas?
Yep.
Maxbauer?
Here.
Fleece?
Present.
Wheelock?
Yes, ma'am.
Chairman Hooper?
Distant.
Okay, at this time, we have a period for a public comment, and those that wish to address the board would please come forward and say your name and address. Seeing none, I would entertain an approval of agenda.
So moved. Support.
Okay, I have a motion of support for the approval of agenda. Any comment? Okay, all those in favor say aye.
Aye.
Opposed, the same? And now we come to the consent calendar.
The purpose of the consent calendar is to expedite business by grouping non-controversial items together to be dealt with by one commission motion without discussion. Any member of the commission, staff, or the public may ask that any item on the consent calendar be removed therefrom and placed elsewhere on the agenda for full discussion. Such requests will be automatically respected. If any item is not approved and not removed from the consent calendar, the action noted, receive and file, or approval is approved by a single committee action adopting the consent calendar. A, receive and file. 1, 4-H in motion, March 2010. 2, housing liaison report and project listing. 3, Grand Traverse Conservation District report, March 2010. 4, Grand Traverse County Road Commission monthly report. 5, Park and Recreation report. 6, aquatic update. 7, 2009 workers' compensation report. 8, 2009 wellness report. B, approval. 1, Resource Management and Administration Committee minutes of March 10th, 2010. 2, grant approval Civic Center solar panel installation and boiler replacement. 3, grant approval retrofitting to energy-efficient T8 bulbs and electronic ballast. 4, window cleaning services authorized contract. 5, copier bids and purchase recommendation. 6, Office Depot Inc. contract renewals. 7, amendment to the Clean Sweep grant fiscal year 2010. And 8, board rules revisions.
Okay, is there any member of the public that would like to remove anything from the consent calendar? Or is there any member from the board that would like to remove something? Ross?
Yeah, I'd like to remove B8, please.
B8. Is there anyone else?
Move for approval. Support.
Okay, we have motion to approve the consent calendar as amended. All those in favor say aye.
Aye.
Opposed, the same?
I guess you should do a roll call on that.
Oh, roll call? All right, let's have a roll call, please, Linda.
Commissioner Friend?
Yes.
Stepka?
Yes.
Richardson?
Yes.
Thomas?
Yep.
Maxbauer?
Yes.
Fleece?
Yes.
Wheelock?
Yes.
Inman?
Yes.
Chairman Hooper?
Yes. Okay, now we'll go to 7A. Niall Deems' presentation and discussion.
Niall, why don't you come up? I'll introduce you a little bit. As the board had suggested, we want to try to solidify a little bit the board's position on how we're going to address the issue of bottomlands ownership as we continue the process of removing the two dams. Niall Deems, who is with Varnum, was hired by the Boardman River Dams Committee to do the initial analysis on behalf of the committee about the ownership and who would have ownership of the bottomlands when the dams were removed. And he did that for the 27 property owners that are adjacent to the property for the Boardman Rivers Dam Committee, and I've included that information in your packet. I met with Niall, and we thought it would be good to have a general discussion with you, the board, to try to get your questions answered, to help kind of solidify and narrow our position on this so that we can decide if there's any action you want us to take to move this issue forward. I'm going to have Niles do a general kind of a summary of what his findings were, and then the rest of the time is for you to ask questions and to kind of assess the position of the board. So, Niles.
Well, thank you. My name is Niall Deems, and I'm with Varnum, Rittering, Schmidt & Howlett,
law firm in Grand Rapids, Michigan. And I was hired in 2006, my firm was, to look at the potential ownership of the bottomlands if the dams, the Boardman River dams were drawn down so that the impoundments were reduced and the exposed bottomlands would be owned by what parties. The essence here is having, I guess, decided that the dams were no longer justified to keep in use for the amount of power they produce because of the expensive cost to refurbish them so that they would be safe. It appeared that the dams were, the impoundments behind them were going to be drawn down. And so we undertook that study. We acquired a extensive stack of title studies from all the lands around for the Sabin Dam and the Boardman Pond Dam. And the Sabin Dam was a fairly simple analysis because it's public land. But we took that and we went back to the earliest documents we looked at were the 1880s, I think, brought it current. The dams were built sometime, as I recall, in the early 1890s. Went into place. A succession of different power companies used them successively. Then, sometime in the 1920s, the power company that then owned it looked around and decided perhaps there might be some issues as to whether or not they had flowage rights over the upstream property that they were impounding water on. And so at that time they undertook and obtained a bunch of affidavits by their employees to say and show how long they'd been using those flowage rights to the extent that they did not own all the land that the impoundment covered. And so they did that in the 1920s. In the 1930s, they then had some transactions with a party, I believe the name was Emerson, to actually purchase and have some conveyances where they exchanged upland that they owned for what would be the bottomlands, the land under the impoundment of the river behind the dams. And so in essence, in the 20s and 30s, they undertook these actions to make sure that they held title to all the lands that were being covered by the impoundment behind the respective dams. So they took care of the title. Now, interestingly, the affidavits weren't recorded until the 1950s, but they were made at that date. The transactions acquiring any of the bottomlands in the 30s, and in the 50s, you see the recording, the affidavits. So we tracked all that forward, and then the other sequence of events, no one seemed to question or challenge the issue that the impoundments were legal, or if you will, by the power companies. That seemed to be accepted. There was nothing of record title that indicated otherwise. And then in the late 1960s, you had two plats that were done actually over the Keystone subdivision. And at that time there was some indication and successively in a few of the conveyances in the Keystone subdivision that some people there were claiming riparian rights. That would be a right to use the water of the river. But it was sporadic and there was no clear pattern to it. And indeed, it's not clear if anyone was actually claiming those or simply thought because the land at the park there in the subdivision and so forth touched upon the water, that there were some riparian rights that might be at issue, and so a few of the conveyances referenced those. Riparian rights under Michigan law, which tracks itself on back through and actually starts somewhere in English common law, is essentially the right of a piece of property that borders on a natural water course to use that waterway in certain manners which do not unreasonably infringe upon the other people using that water course. Okay, well, riparian rights do not arise for property that touch an artificial body of water, one created by an impoundment that's artificially created. So you cannot live on property that touches Boardman Pond and claim riparian rights unless you actually own the land that goes to the natural water course. Well, that, of course, would be the Boardman River in its original water course. And as, from everything we could tell in searching title and all of the abstracts we looked at, which were fairly extensive, all of that property was picked up by the power companies in the 20s and 30s if it wasn't owned before then or acquired by an adverse use before then. And so therefore, the net result of our analysis of all of this was simply that the property ownership of the bottomlands was in the power companies, and then it comes through a succession to the county, who gave an easement to the Board of Power and Light to use it, who have then surrendered that back to the county. And so title to all those bottomlands is in the county. We did not see anything that suggested that the property owners that adjoined the impoundment had claimed any riparian rights. And the thing to remember is, to the extent I don't know that any of those people have claimed to own the bottomlands. Perhaps they do, but I did not see it in record title, so if anyone's alleging that, it's nothing I saw in the record title of the county records. And so, since they don't claim to own the bottomlands, they don't claim to own to the water course of the river as it originally was. And so it seems to me what they're seeking to claim is simply that they have, if there are any such, a riparian right, which is a right to use the waterway and not infringe upon the other people using it. But to do that, they need to touch that water course. But in any event, if they're claiming riparian rights, what they're claiming is simply the right to go out there and fish or take their canoe on it or swim in it or something of that sort. And any other issues, such as, I don't know, if you draw down the impoundment, it reduces the value of my property or something, don't have anything to do with any issues of title or ownership that I'm aware of. It's simply the type of question of, the pond was always there and I liked it, and I wish it weren't drawn down. But since it's an artificial water course, I believe simply under the cases that exist in Michigan law, the county has a right to do that. And indeed, if the county, as a matter of trying to decide if it's good for the general welfare of the citizens of the county, wants to keep the dams and pay the cost of keeping them there, they can do that. If they want to take the dams out because they don't have the money to reinforce them to the safety standards, they can draw down the impoundments and take the dams out. And there are no title issues that should impede that in terms of the property owners around Boardman Pond. And I can go on further, but it might sound repetitious.
Questions?
I have a question. Now, you're saying that just because in the 60s they made a plat and gave title to some of these people, for instance, number 9, I guess, in Keystone, that's on page 67, that they have conveyance, title deed, they're supposedly granted riparian rights. Now, that doesn't necessarily mean that they have it, evidently.
That's right. That is, not to be too facetious, but that's like me conveying you the Brooklyn Bridge, the old story. Just because somebody says, okay, I convey Lot 9 to you with the riparian rights, that doesn't give you riparian rights. It's only if that piece of property actually held riparian rights at that time. Riparian rights are an appurtenance that go with the property. So if they belong there, if record title shows that it's riparian property, then when you convey it, it's there. Otherwise, the conveyance is, they were probably simply mistakes because the impoundment had been there for a number of decades. And as I say, some number of people I think just got to the point where they assumed it was there, almost like a natural body of water. And indeed, that's not unusual when we've seen some dams washed out in Michigan. People get quite upset at the thought they might not be reinstated. The trouble is the cost of rebuilding the dams and building it to a safe standard. So if the land originally went to the natural water course, it's riparian. If it didn't, it's not riparian. And there are some of the conveyances, as you referenced one, particularly over in the Keystone subdivision, there's a handful that have a suggestion of riparian rights. But there's nothing to indicate that that piece of property on which the two subdivisions are located, was ever riparian land.
Okay, and to follow up now, you mentioned also too that there might be title insurance on this property and that these people might be eligible for a claim. Since you did this in 2007, have you been aware of any making a claim?
No, I'm not aware of any. I haven't checked that. And I don't know if anyone ever got a policy that ensured that they had riparian rights. Title insurance, when you buy it, it says here's an insurance policy that when you buy Lot 9, you own it. One of the things that should be done if you're going to properly insure your land is any of the appurtenances that go with that land, make sure they're also specifically listed in the insurance. That would include, for example, a driveway easement or some other easement that goes with the property uses. And a lot of times people don't do that. They just get title insurance for, let's say, Lot 9 without getting it to cover the driveway easement or getting it to cover riparian rights or whatever else the appurtenance might be. So I'm not aware whether or not they had those, and I'm not aware of anyone that's made a claim on that basis.
Sonny?
So if I understand this correctly, in the 20s and 30s and registered in 2000 or in the 50s, there is actually a physical description of the bottomlands registered, titled to Grand Traverse County?
Not the county, it was the power company that owned it at that time. The county is the successor in interest to that history of title. It starts, I don't remember the name of the first power company in the 1890s.
So that title should be changed then, so as
Well,
it
no,
shows, or it's not necessary?
in this history of conveyances, for simplicity's sake, let's just call it Power Company 1, and then somewhere, I think in the 20s, they conveyed a Power Company 2. All the dams and all the bottomlands, the impoundment area behind them. And then that goes to, I think, a third power company, and then I think a fourth power company before it gets to conveyance to the county and the allowance for the Board of Power and Light to use it until they surrender it, and then it's back to the county. So the county's name shows up in title, and they take title, I think it's in the 1960s, from Consumers Power, if I recall correctly. So it's clear that that's been conveyed to the county now. I think the only thing that some people are alleging is not that they own the bottomlands, but somehow they have a right to claim that they are riparian and will still somehow touch the waterway even when it's in its reduced state. And I frankly don't see how they claim that. If their land ends here where I'm sitting in, let's say, the Keystone subdivision, and the natural water course is the desks that are in front of me, how I'm going to get from here to there and claim I touched that water course, it escapes me how they're going to claim that.
Right. But there is a physical description of the bottomlands, and there is a title for that property.
Yeah, it was first, I believe, described in the affidavits of covering the bottomlands. Then with the conveyances with the Emersons that I think were 1930 is when they actually split. So the upland was with the Emersons, and they had the conveyances and the descriptions of the property that laid out the distinction.
From a historical perspective, I'm going to point out, too, that prior to the time that the Borden River Dams Committee hired Nile to do this review, we had asked Al Schneider to do a review as our county prosecutor and civil counsel, and Al came to the same conclusion. We met yesterday, Niall and Bob Cooney and Al Schneider, to just have a kind of just discuss this further, and I just want to point out that I think there was agreement among the three that that the property owners have no legal right to that land, that it is in the ownership of the county according to those three, and so I just wanted to kind of point that out to you.
Yes, sir.
I got a couple questions. One is like Lot 9 that was conveyed by warranty deed?
Well, I don't remember exactly, but I would imagine so.
Well, that's the one that,
Okay.
It's
Yeah,
one
so
of
it's
the-
conveyed by warranty deed.
well, how can you convey something by warranty deed if it isn't true?
Well, for two reasons. Probably the most logical one is they thought it was true. But that doesn't necessarily mean that it is. I think it was simply mistaken, and frankly, you get a number of things in record title that people put there that when you try and track them out, whether it's the attorney or the real estate agent or the title company, they thought something applied, but then when you check the history behind it, you discover that that really wasn't the case. And so I imagine what happened, and as I say, because we saw some of the references to conveying riparian rights in some deeds in the Keystone subdivision, we went back through the history of all the conveyances in the entire subdivision. And it's only a very sporadic occasion when those are mentioned, the riparian rights. And indeed, even, for example, if I would have to look here to find it, but if, let's say it's Unit 15, there might be a time where riparian rights are conveyed, and the next three conveyances in Unit 15 won't mention them at all. And then maybe they'll show up again. And so it's just intermittent. There's no clear pattern that suggests that either the parties that laid out the subdivisions or the people that successfully bought lots in the subdivisions had a clear and distinct understanding that they own riparian rights and tried to show that consistently in their conveyances. It just isn't there. It's only there intermittently.
I was always taught that if the difference between a warranty deed and a quitclaim deed is whether it was true or not.
Well, and I'm sure those people that thought there was a reason to put it legitimately, it just, as we search back the history of the title, there wasn't.
My other question is, and I was looking for it in here, but there were some other properties on the backwaters that are not in here. In other words, meets and bounds parcels, there's a few of them. Do any of those have any shot at, because I know of one property that was owned by the same family since the 20s. They've got about 5 acres left now, but do they have any shot at riparian ownership?
Well, I'd have to look at who you're talking about, but I think, as I understood it, we acquired the title searches for everybody that touches on the current impoundment, and found essentially the same history to be true for the entire impoundment.
Hey, Ross?
So the boundaries of the impoundment have not really changed historically?
Well, not particularly. The reason I say that, as you can imagine, once you build the dam and you have the outlet of the dam, you know what the high water point of the impoundment is. And so topographically, the land that's going to be impounded isn't going to change much.
Okay, and that's defined as
It's
the high water mark of the impoundment?
Well, essentially, yes, because any water above that's going to flow through the overflow in the gates.
Okay. Do you know how the bottomlands were conveyed to the county back in the 60s? Because the county really didn't have any interest in the land at that point, did they?
Well, it wasn't I think what happened was, if I recall correctly, I think it was Consumers Power at the time, was using the dams and decided they weren't worth keeping anymore. That seems to have happened several times in the history of these dams. They just didn't, for the electricity they produced, it just wasn't worth it. And I believe at that time that they conveyed them to the county. I think it was one of those deeds that says for $1. And so it was conveyed to the county, and the county in turn granted a right, I think they called it an easement right, to the Board of Power and Light to restore the electrical usage and continue to use those, and that would terminate whenever they stopped using it for electrical production, which has subsequently occurred.
And one other question, the course of the river was changed when they built the dam?
Well, the course of the river, I'm not sure was changed.
Well, no, it was.
But perhaps it
At
was
some point,
because they moved it to line it up for how the dams were going to exist, yes.
Okay, so if you had riparian rights and then the course of the river changes, then you don't have them anymore, basically? Or?
Well, except that in the history of that, if the channel was here and they moved the channel over here in order to get a better effect for the dam flow, what they did was move it within the same area of impoundment, and then even if in 1894, I think it was, they did not have the right to flood the whole impoundment, they nevertheless did, and subsequently took a number of steps to be sure that they owned title to all the lands in the impoundment. And so the entire impoundment is now covered in that title the county has. And so whether the course of the river is here or here isn't going to matter.
Well, I was actually talking about downstream from the dam.
Okay, downstream and towards the city?
Right, to the north.
Well, we looked at from the Sabin Dam south. We only looked at those two impoundments, Sabin and Boardman Pond.
Okay, well, it was the river at the Boardman Dam that the course was changed.
But it was
I'm playing devil's advocate here. I'm not sure it really matters. I was just curious.
Yeah, I don't think it matters because you're still within the impoundment area.
And Ross, it was changed from, I believe, the normal course was on the northern end of the pond, was on the west side of the
Right, it
dam,
was changed to
which
the
is
east
the
side.
land that's owned by the county
Now.
as part of the education reserve.
Right, so you own a lot of the upland, and you own all the bottom land.
Okay.
Other questions? I guess I kind of initiated this discussion because I had a concern about, from a strategic standpoint, about how this might proceed. We're in the process of taking out the dams. We're working with the Army Corps, and they're doing the engineering and feasibility study. And we know, of course, that the property owners are not happy with this result, and the property owners have numerous times first asked what the county's going to do with the land, and then secondly, they've asked, or we've offered to go to court with them and try to get this issue of ownership settled once and for all. And my main concern here was that it would be prudent to do that early on in this process than wait till we get to the day we're going to start taking out the dams and find we have 2 years of litigation following. In my discussions yesterday with the attorneys, a couple things became apparent to me. First of all, that, and it was Al Schneider who brought this up, the issue of ownership of the property really should have little impact on whether the dams come out or the dams stay in. In other words, there may be challenges to the permits, but the dams coming out and dropping down the water level still leave open the issue of ownership if there is in fact an issue, although our attorneys don't believe that there is an issue. And so their feeling is this is probably not going to impact the actual dam removals, which was my concern. But we will still have the issue with the property owners to engage them. And so I don't know that, I saw some immediacy to this. I don't know that there is at this moment. But I think it would be prudent on our part to be thinking about what we would want to do with that land, assuming it's in county ownership, because the attorneys basically are telling me it's going to be in county ownership. So I think to start thinking about that is probably a useful exercise for us to go through. Whether you make a determination that you'd like to turn the issue over to the Nature Education Reserve Advisory Board and the Soil Conservation District who manages that park for us, and ask them to look at developing it in some way that they think is appropriate in terms of a plan, so that we could take that out to people and show them what we're thinking about doing when that dam is removed, or whether there's another alternative that you'd like to investigate. I just wanted to get that issue before you, but I feel much more comfortable after talking to them that we really don't have a need to do anything from a legal standpoint at this point in time, but we're rather probably look at it from a planning standpoint in terms of getting the word out to the public on what we think the reuse might look like, and then that gives them the opportunity to react to that. So that was kind of my comments to you, but I'm looking for some further direction from the board if in fact there is any.
Thank you, Beth.
First, I have a question. This was written in 2007, so we've known for a while that it's legal opinion that we own the bottomlands. Why has it taken so long for us to, strategically plan what would we do with those bottomlands?
Simply a matter of trying to figure out where we were at in the process, whether it looked like the money was going to be there to be able to remove the dams, figure out what direction we were going with. And frankly, there was no need to pursue that at that moment in time. There's no other reason than that, Beth. To pursue that issue with the property owners prior to knowing where we were going or knowing that we were actually moving forward, in my mind, didn't really make a lot of sense, especially because the minute you sit down with the property owners, you have to be able to tell them something. You have to be able to have a plan, and frankly, we didn't know where that was going at the time. I think we have a better idea now, and it looks to me like the dams will be removed, and it looks like money will be available. I understand we've already gotten a $500,000 or $600,000 grant to start this process, so there was no other reason than that.
One thing I'd like to see is, given the ownership of the bottomlands of the county, I would just like to see kind of a paper given to us, maybe generated by staff, that just gives the different options of what we may do with those.
Well, we can certainly do that. We had talked about that before.
I guess just an analysis of the different options.
Yeah, I don't know that we could be exhaustive about what the options are. But I think we can do
the
that.
options would be fluid too as the thing progressed. There'd be different options as we find out what's going on.
I assume, Bruce, that what we would do is we would look at this from the standpoint of when the dams are out, and that's kind of how we would best look at it. I think that's, to give you an inventory of the options, I think is fine, and we can do that. And I probably can get that to you in a couple of weeks. I don't think that's a big deal, but I guess I'm going to caution you. There's a second issue that I think you have to be aware of, and that is the issue of the public trust and the public dollar. Okay, and it's this issue, and actually Niall brought this to my attention. One of those options, of course, would be giving the land to the property owners or compensating them in some way for their lost lake frontage. But in order to do that, they have to have some, I think, tangible damage that that they can show, because you can't take public dollars and then use them for for a purpose that does not benefit the public. Okay, so in effect, if the conclusion is the land is owned by the county, and Niall, correct me if I'm wrong in this kind of concept, if the land is owned by the county, to just hand it over without some public benefit may not be appropriate. Is that one way of saying it?
Yes, one
You've
thing.
probably got a better way to say it.
Well, not really. One thing that struck me was I think in the discussion something came up about should there be compensation to the private property owners around Boardman Pond for their loss of their waterfront. And I thought, well, I'm not sure that they've lost anything. They didn't own it to start with. And indeed, even if they're claiming those riparian rights, the dam is a regulated matter. If there's a reason for the county to keep the dam there, fine, but as I understand it, there aren't the funds. You're going to take the dams out. And so in doing that, the river is going to return to its original water course, or its adjusted water course anyhow. It's going to go down to where it can flow now. And all of that land between the properties as they now are on the edge of the water and the reduced flow of the river is county land. And so if you either pay them for the loss of that land or give them that land, you know, you have to look at it in the sense of you're giving up something that you hold for the general welfare of the people in Grand Traverse County as a whole. And I understand it's not just to make these people mad, but I used to be an elected official, and one of the hardest things was sometimes to, I remember, keep ourselves focused on we're here for the general welfare of the whole entity. And so it simply struck me it's hard to justify you know, any compensation for the loss of something, because it's a loss of something that at least every analysis that I think has been done, we did an exhaustive one, I know Al did one before we did, says, well, they really don't own it. In contrast, for example, if you're going to have a county park there, well, they'll have access to the county park. And indeed, that will give them access to the water to go use the water, subject to your regulations. And that's all they're really claiming anyhow. If they claim they have riparian rights, they're claiming somehow the right to get there now, but then they're asking perhaps to extend their property lines from here at their lot all the way down to the river and take that chunk of land, and I don't think you're in a position to do that anyhow.
So the answer is, yes, I can get you that. I'll give you maybe a two-line explanation of each one, you know, where we see it from a strategic standpoint. I guess I can have that done in a couple of weeks for you.
Just to understand what I'm asking for, you kind of got into the details of one option.
Mm-hmm.
I'm not interested right now at this point in here today discussing the pros and cons to one option.
Mm-hmm.
What I'm asking for is give me the options, and in this paper you can denote some of the things that would be challenges or that would not work.
Well, and we can certainly do that, but from my perspective, what I don't want to do is give you a list of options and then have, you know, word out there that one of the options the county board is considering is compensating property owners for land when it may not be at all an option realistically. So that's my only concern with that. So I can provide you with a list of options, but I just think we have to be very careful with it so that the wrong message isn't sent to the public or to the property owners to give them hope that maybe they should not have.
Yep, and exactly in the case when you write something like that, you can say in there, this doesn't seem a feasible option because of these things.
Okay, I'd be glad to do that, and I can have that for you in a couple weeks.
Larry? I guess I'm not understanding why we would need, as a board, a list of the options. It seems to me we have taken a position that we're moving forward with the demolition, and we've got a process underway. And it seems to me that if the property owners wanted to react to the actions that we have set forth, that we would respond to them based on what they would bring forward in terms of what they think their options are. And we would respond accordingly. I mean, and I guess the second point of that is that if there's any expectation in the future that the property owners would come together and perhaps file a lawsuit and contest this thing in circuit court or whatever, that it seems to me that all the multiple options that they would have available that we or may not consider would be up for legal discussion and legal debate. And I don't know if it would be appropriate for us to disclose our position as we see in terms of options from a legal perspective. I mean, maybe you can help me with that.
I tell you, here's what would strike me if I were trying to sort through this analysis with you. And in part goes to what led Dennis to raise this issue is you're going through a process, you're already a number of steps into it, as you note, and money's being expended to draw down the ponds, to take out the dams, to restore the river. Okay, and you know, my letters that I sent back in 2007 said you had a right to do that. Al raised it again yesterday. You know, I concur, you have a right to it. That's always been something that seemed just apparent to me in the analysis. You know, you have a right to do it, you're going to draw down. In the sequence of things that arise, there's some people that are upset over this. You know, their life is changing even if they never used Boardman Pond. They used to look out on it and it's going to change. Okay, so they'll be upset. I don't know if any of them will file lawsuits or not. But in the sequence of things, what strikes me, I was hired in 2006. You're now in 2010. You're 4 years later. So as you're going ahead with this process, to the extent you can at least think of how you're going to use this, I'll call it parkland, this parkland the county's going to own, as a nature preserve, or whatever, whatever you do with it, you can go ahead and get that review and study started, however you do that, so that that is known, because in the sequence of things, if you're going to have some property owners that try and contest what you're doing, well, you might as well bundle all that together and take care of it now instead of it showing up 2 years from now when you think you're done. When I say now, whenever it happens in successive months or in the next couple of years, take care of it all at once in that standard. And when you're doing that, both for the property owners to feel comfortable, because right now they face the unknown. The pond's just simply going to be drawn down, and what do they have? And so the more they see the county studying what they're going to do and a plan evolving for how you're going to use the land, it perhaps calms some of those property owners because they're going to know what they're going to get or what the alternative is. And secondly, if you do wind up in court, as the judge is sitting there listening to some people complain in the county saying we're going to do this, the more he can see how the whole picture unfolds, the easier it is for him to sort it out and clean things up. So that's not so much a matter of law, that's just how it starts to look to the judge as he sorts it out. And it's going to be a lot easier for him to draw the picture, not because there's anything that legally changes, because although the people are complaining they're losing their riparian rights, it's much easier for him to focus on, well, how much are you losing? You're getting a nice county park at a river there. You know, what is it you've lost? And I think it will simply help you in the practical manner if you can be proceeding in a bifurcated manner.
Okay.
Well, there is, and I don't have the name of it, but we could start action in court to nail all the titles down, right?
You could, it's called a quiet title action is perhaps the name you're searching for. And you could start that now, or you could wait and see if anyone is going to do that. And what you're doing then is, because you have some people that have raised the concept, the stigma, the whatever, that they are claiming they have these rights that you think are contrary to your understanding of your ownership of the land, and they're going to assert those rights. And so, rather than wait until the County Public Works Board is out there doing something on the land and these people come out to complain and stop them in whatever manner they think they're going to, you can preempt that. Or indeed, if they want to file a lawsuit, they would presumably file in the same name a quiet title action. If you're filing it, it's the quiet title for the judge to say, it's clear, and your position is, it's clear the county owns this, and you people don't have these riparian rights, and so the dispute over that title is quieted. And from their perspective, they would file it with the court saying, please quiet title with our claim to riparian rights and declare that we have the riparian rights.
That's something the county could initiate?
Yes, you could initiate. Now, it's a suit that you file to clear up something that you've been told you know is disputed. Picture it if two neighbors are squabbling over where the boundary of their property really is, and they can't resolve it with themselves. One or the other can file a quiet title action to say, we're fighting over where this boundary is. So we're bringing the case to court. One or the other of them can file it. So the court can, quiet title, can declare where the boundary line actually is.
Okay, Sonny?
Well,
Oh, go ahead. Sorry.
I think it would be good planning on our part to do that and have all the questions answered before we get down the road and then find out, we got a problem here, and Joe Blow wants to hold us up for 4 or 5 years.
You do not need to do that as part of going ahead with your permitting process and your actions to take down the dam. I put that in my letters, I'll raise it again yesterday. But there's also a clear logic in what you're saying, that somewhere in this process as you're doing this, if by whatever feedback you're getting, you know some number of these people are disputing your position, to go ahead and start that process so these things run in tandem, with your plans for how we're going to use your park, so that you can bring them to completion all at once, instead of waiting to complete 1, then do 2, then do 3. It's already 4 years old, and hopefully you'll be finished.
See, and that's where I was originally going, and that's why, I'm I don't mean to be hesitant, but I am, because a lot of this is strategic in the way we approach this. But what Niles said at the end of that statement was, you go forward with that along with your plans for what you want to use the property for. And what's critical about that is, if their claim is access to water, and you can go into court and say, here's our park plan, and they will have access to this river, and this river's going to have kayaking and fishing and so on and so forth, and we're going to have boardwalks and this and that, the judge may look at that and go, well, where's their argument for access to water? They have access to water. It's a public park, and the county's going to take care of it. So to just go into court and say, we own this, well, you're not giving the judge maybe the full look at how this impacts them. And so I've been convinced that having a plan is important.
And here's the distinction there. I don't think there's any question that you own it. And I think the judge will come out that way as well. But if you think there's 27 people here at issue, let's just declare they're all upset with your plan. And let's put all 27 of them in opposing you. Just like when the 27 people are complaining about what you're doing, you slow down your process to study a little more to try and be sure you're being fair to them. When everybody shows up in court, and the judge sees 27 people complaining, and here's the government saying we own it, the judge may just take a little bit more time to sort it out to make sure these 27 people get dealt with fairly, just as you do a public entity. And the more you clean up that picture as you're going forward, if and when you have this lawsuit, it's likely to progress much more easily and more quickly. And indeed, because a lot of the property owners now know what's going to happen to them, instead of 27, maybe you'll have 0, maybe you only have 2 or 3.
6. Sonny?
Well, I guess, this process is 5 years old now. We've been working at it, and, we've heard repeatedly the county owns the bottomlands. I don't think, we as a group and the Boardman River Dams Committee as a group, I believe, come to that consensus. There's a half a dozen property owners that do not agree with that, and it's just that simple. And somewhere along the way, I'm afraid that the judge is going to have to make that determination. But the fact is, it's not all of the property owners. It's a handful of the property owners that are truly contesting the legal statement, which we're contending is a statement of fact that we own the bottomland. Probably, you're right, Dennis, at some point we're going to have to do the court thing, whether we do it with the quiet claim deed or however we do that. What I'm seeing primarily is we need to be moving forward with a plan of what we're going to do with that land that we own that will now be exposed once the pond is gone. And we have a couple of real easy options. We can ask the Planning Commission to look at it. We can ask our Parks and Recreation Department to look at it, or we can ask the Nature Education Reserve Board to look at it. In my mind, it makes sense to add it to the Nature Education Reserve. So, maybe a joint meeting with some of these folks makes some sense. But I believe we do need to start developing a plan of what we're going to do with the bottom land that we will own, or we do own, once the impoundment is gone. And, it makes a lot of sense to me to start developing a plan for that. I don't have any question in my mind whatsoever. At some point, a judge is going to have to tell those half a dozen property owners, you do not have riparian rights on land that you do not own. The county owns the land, period. So whether we do that now, whether we do it a year and a half from now, I don't know that it makes any difference whether that happens now or whether it happens once the dams are out and we actually know where the river's going to flow to. You know, I'm almost inclined to think that that comes at such point as we actually know where the physical river is, because we don't at this point. So, you know, those are my thoughts is, you know, we've been at this a long time. I give the people that have been participating in this process a whole lot of credit because they got a lot more patience than I do. But the fact is that if you've got 75 people in this room, everyone but about a half a dozen of them agree that the county owns the property. So we need to be working on moving forward with developing a plan of what we're going to do with that property.
Okay, any other questions or comments? Larry?
Well, I think as far as Beth's question or comment, I think there's really only two choices. We deem it surplus property and we sell it, or we decide to retain it, and like Niall said, and I agree 100% with him, once those property owners understand what the county at least is thinking, obviously I believe we would consider keeping it and making it into parkland of one type or another, and pursuing that avenue. I think that'll put a lot of their fears at rest. I think Dennis's earlier suggestion to maybe for this board to turn it over to the Nature Reserve Center Board to review it and come up with some suggestions, I think is a good one.
Okay, and I would like to add that the Conservation District has been spending the first quarter of this year strategic planning, streamlining, weighing what programs they're doing and what options they have, and one of their main goals is the work of the Boardman River and helping shepherd this restoration project. All right, thank you. I think we're done.
All set?
Thank you.
Appreciate it.
Appreciate the opportunity to chat with y'all.
Have a safe trip back.
And now we move on to item B, Register of Deeds, elected official salaries, on page 79.
No, I can call you.
And
Thank
would
you.
you like to open, yes?
Yep, I just wanted to point out that Peggy Haynes gives her apologies. She's at a conference and unable to be here today, and so she wanted to have this issue discussed with the board again. And she is requesting that she be given a car allowance as has all of the other elected officials. Now, one elected, or either every elected official has a car or has been given a car allowance. Al Schneider turned his down at the time that the car allowance was first offered to him, I believe in 2005 or 2006. And if you decide to give the Register of Deeds a car allowance as compensation, my suggestion would be that you make the same thing available so it's the same for all elected officials. I did want to kind of clarify my position on this so that the board understands. I don't believe any elected official needs a car allowance, and I believe the Siegel study showed that. Okay? But, well, I shouldn't say, yes, a car allowance. The sheriff may need a car and things like that. But my position on this, and my recommendation to you long ago was, if you look at the Siegel study, it showed that the elected officials, they are not all being compensated where they should be compensated. Peggy Haynes is one of the ones not compensated at the appropriate level. I think the clerk is one of the ones not compensated at an appropriate level. There were 3 or 4 that maybe were compensated at a lower level, which I think supports kind of what happened with the county board, right or wrong. I think what happened was the county board back several years ago, used a car allowance as a means to help compensate in some way for maybe not having the salary that might be considered fair. So my position was when Siegel salaries were implemented and everybody was paid fairly, then car allowance should be taken away from those elected officials, just as the elected officials in our Siegel study market don't have car allowances for the most part. But until then, I think the situation that has arisen here is elected officials had their salary set, and then gradually, a number of them, and they remained relatively the same, and then gradually a number of them were also given a car allowance, which raised their compensation. And Peg's argument is, so that even put me, even though she's the lowest paid one other than the drain commissioner, that actually put her farther behind, because they all got this additional compensation and she did not. And I think that's the argument that she's making. So I just, it's there for your review and consideration.
Okay, Beth?
Did we review this earlier, like within the past 6 months?
Yes, I think you did it maybe 6 or 8 months ago.
And what
yes.
was the result of that, do you remember?
Well, the vote was to not allow a car allowance, I believe.
Right. Well, the discussion, if I recall, was to eliminate all of the car allowances, or at least my discussion was to eliminate all of the car allowances.
But that did not.
But we didn't do
Right.
that.
Right.
Chris?
Well, I support this. First of all, I agree with Dennis. I don't think any elected official ought to have a car allowance. But they do. And I think that we need to be consistent in how we treat our elected officials. And we're not being consistent. And so anyway, I guess I would make a motion that the Register of Deeds be given a car allowance.
Support.
Okay, we have motion support. Any comment? Larry?
I just question, is Bob here? I guess the question is, since we've already made a decision on it, so we need should we first make a motion to reconsider?
No,
It was
it's been
too
long
long.
enough.
It's been long enough.
Has it been long enough?
Yeah, I think it's
It's been
fine.
more than 60
All right, okay,
days.
okay. I guess I have a
Oh,
comment.
sorry.
Yeah, I also support this. I did vote originally for having the car allowance for Peggy back when we had first addressed this regarding elected official compensation. And I can't remember if it failed 4-4 or something. I don't remember the exact vote on this thing, but in any event, Peggy had asked a group of commissioners to get together and just briefly discuss this. I think it was Commissioner Maxbauer and myself, and was it Commissioner Thomas?
No, it was me, and I had to leave.
You? And so in any event, our suggestion was that, if she felt that strongly about it, that she should bring it up for, reconsideration for the board, and we can discuss it and take another vote if that was appropriate, so.
All right, we'll go Ross, then Sonny.
Did you want to put a dollar amount in that motion?
I would set it at the clerk's is my recommendation.
Okay.
Same as the clerk.
I would amend the motion to set it at the same level as
Yeah.
the county clerks.
I'm sorry, I don't, what is it, Linda? Do you know? I can't remember what yours is.
$450 a month.
$450 a
That's
month.
all the elected officials are the same.
Are they?
Yes.
Okay.
All right, and Sonny? Is that?
Well, I guess in my mind, if we're going to do this, I would rather put the $5,400 to her salary and eliminate the car allowance. I just think it's, every time we add these car allowances, people, we had a system for a long time where we did classification rechanges, and all it boiled down to was people wanted more money. And they were here arguing for the more money, so they wanted a classification change. As far as I'm concerned, this discussion about having her have a car allowance is nothing but she wants more money. And I don't believe that her job requires a vehicle that she's going out of the office all the time to do. So I don't know that a car allowance is the appropriate place to expend the money. If we want to have a discussion about expanding her salary by the $5,400, I'm willing to vote for that, but I will not vote for a car allowance because I don't believe a car allowance is justified in her job.
Beth?
Well, there's a couple of things. One way would either be, when you're looking at this, you're either increasing it because what the Siegel study showed. Now, the last I checked, we were reviewing the Siegel study. I don't know that we should necessarily make any changes based on a study that's under review. Or number two, you're changing this because other elected officials receive a car allowance, so you give this elected official a car allowance. I don't agree with that, just for some of the reasons that Sonny just stated. Now, however, I would contend that it seems that her salary seems lower, but what I've asked for is show me other registers of deeds salaries in a large number of counties. Or show me how the work has changed in your office, over the past period of time, or what progress or efficiencies that have been made. Show me that. Let me base something on that, not a Siegel study that's under review or another car allowance.
I was going to say, part of her argument, too, is that people in her office that work underneath her are getting raises, and she hasn't got one since she's been working. Chris?
Well, I'm not really basing my motion, Beth, on the Siegel study. I think it's strictly an issue of fairness. This board has been consistently fair in setting, in my opinion, in setting salaries for employees, and I think that her situation is not a fair situation, and that's why I made the motion.
Ross?
I agree with Sonny. I don't like car allowances. I mean, as far as I'm concerned, they are compensation by another name, but I actually tried to resolve this last fall by eliminating car allowances and resetting the salaries, and I was the only person who voted for it, so I was surprised I actually got a second to the motion. It is an issue of fairness, and before we can, I think, reset the salaries or look at the whole compensation issue, I think we have to at least put our elected officials on more or less the same playing field. And the problem here is that Peggy, the Register of Deeds is not on the same playing field as the rest of elected officials. I don't think that's fair. So I will vote for this.
And I just have a problem with, as Sonny said, just give them a raise. Well, then here you're giving one elected official a raise without giving the other elected official a raise. So this way you're compensating. This may be a distinction without a difference, but here you're compensating them the same as other officials without giving them a raise, whatever. So I don't like the idea of saying we're giving her a raise to make her compensatory with everybody else, but here we'll give her a benefit everybody else is getting. Sonny?
Well, I guess the point is, I think our documentation shows that there is an inequity in her total compensation. So I don't have a problem discussing her compensation. But I can't support giving her a car allowance because her job doesn't justify a vehicle.
Larry?
Well, I think I like your point in terms of leaving the salary alone, because we would leave, in all fairness, the salaries for other elected officials we would be leaving alone. We would just be adding a car allowance, of which the other elected officials have, but she does not. So in terms of how we define this process, I would prefer at this time just to add the car allowance for parity purposes. So that is the motion, I believe.
Yes.
Okay, all right.
Dick?
Well, I feel that the car allowance is a stopgap measure to help prove to Peggy that we think she's doing a good job, which I think she is. However, if you're going to put it out in the form of a salary increase, whether it be for her or anybody else, the way the economy is right now, I'm not in favor of doing it that way. So this is a stopgap measure for Peggy, that's fine, but I'm not going to stick my neck out and start giving raises to people when I know hundreds of people that don't have any salary.
Okay, I think we've reached a point where we can vote. I think we'll have a roll call vote, please. Linda?
Commissioner Stipka?
Yes.
Richardson?
Yes.
Thomas?
Yes.
Axbauer?
Yes.
Fleece?
The motion was to give her a car allowance?
Yes.
No.
Commissioner Wheelock?
No.
Inman?
Yes.
Friend?
No.
Chairman Hooper?
Yes.
Okay.
5-4, motion carries.
6-3, wasn't it?
6-3? I was just doing what she told me.
I have 5-4. Can I repeat the vote?
Yes.
Commissioner Inman voted yes. Friend voted no. Stepka, yes. Richardson, yes. Thomas, yes. Max Bauer, yes. Fleece, no. Wheelock, no. And Hooper, no.
I said yes.
Oh,
Hooper
that's
was
right.
yes.
Oh, sorry. Thank you.
Okay. Got a cold. Okay, and now let's move on. Item C, Parks and Recreation Resolution and Bylaws. Page 80.
In your packet, there is some information regarding the rules and regulations with respect to Grand Traverse County Parks and Recreation Commission, as well as bylaws of the Grand Traverse County Parks and Recreation Commission. The rules and regulations are based on findings from an 8-person committee who was partially appointed by this board, partially appointed by the Parks and Recreation Commission, including Commissioners Wheelock, Maxbauer, Stepka, Parks and Rec Commissioners Clark, Byrne, Ruskowski, Bob Cooney and I were both part of the committee. And before you, you'll see a proposed rules and regulations with respect to Grand Traverse County Parks and Recreation Commission. What I'm asking for are 2 motions, one to approve the rules and regulations, and the other to approve the bylaws of Grand Traverse County Parks and Recreation Commission, as approved by Parks and Recreation Commission at the meeting in March.
Sonny?
Mr. Chairman, I know we need to talk about the rules, but I think the first piece that we need to do is to evaluate the new resolution by which we've granted, this board grants the Parks and Recreation Commission authority, and that would be resolution dash number that's on page 81 in your packet. We spent a good deal of time reviewing the old resolution, which had a lot of antiquated terms and just things that absolutely don't fit Grand Traverse County anymore. And I believe the first thing that we have to approve is the resolution that gives the Parks and Recreation Commission its responsibilities and how it will do business. And that would be the resolution. And therefore, I would move to adopt Grand Traverse County Board Resolution on page 81. This is the Rules Committee. There was a resolution that's made up the makeup of the Parks Committee.
And
That's what this is.
Okay,
This is the new-
all right, so it's been added to the front of the rules then? Because it was a separate document when we had it before.
Correct. And this resolution is actually approving the rules and regulations with respect to Grand Traverse County Parks and Recreation Commission.
Okay. I will move to approve the resolution.
Support. Okay, so that would be essentially number 1 in your recommendation?
Yes.
Okay. All right, so we have now a motion to approve the rules and regulations with respect to the Grand Traverse County Parks and Recreation Commission as presented. Okay, any discussion? Okay, all those in favor say aye.
Aye.
Opposed, the same? Unanimous? Okay, well, we have a second motion, do we need to make, right?
Second portion of, or my second recommendation would be an additional motion to approve the bylaws of the Grand Traverse County Parks and Recreation Commission.
So moved.
Moved by Friends, supported by Stepka. Any further discussion? Ross?
Well, first of all, I was not part of this at all, but I would like to commend everybody on, it seemed like you got this done really fast. I mean, considering the size of the task and how long it had been since you did it, so just, congratulations.
Well, may I?
Chris?
Actually, kudos where kudos are due. Mr. Cooney's not sitting here, but he did an absolutely fabulous job, as he always does.
Okay, we have a motion to approve the bylaws of the Grand Traverse County Parks and Recreation Commission as presented. Any further discussion? If not, all those in favor say aye.
Aye.
Opposed, the same? Motion passes again.
Jason, as long as you're here, I've got a safety concern over at the pool.
Okay?
I went swimming yesterday afternoon, and the water's extremely cloudy. I was told, and I'd like you to investigate this, I don't know if it's true or not, I was told that management instructed staff to put 50 pounds of sodium carbonate in the pool, and it clouded it up almost immediately. I was told that management instructed staff to put another 50 pounds of sodium carbonate in the pool, and you know that raises the pH sky high, which would explain why the pH, when I first came back from Florida, was at 8.1. And I tested the water over at Larry's because it was so cloudy and it felt strange. Literally, you can put somebody at the bottom of that pool, and from where the lifeguard sits, you can't see that they're at the bottom of the pool. I swam in 7 swimming pools in Florida, and 50-meter pools, you can be underwater from one end and see clearly to the other end of the pool. You can't see 6 lanes across the pool underwater in ours. Something is wrong with that water.
Well, Commissioner Max Bauer, I received a concern by you last week late. I apologize I haven't sent you what I got from the Health Department, but I know you test the pool yourself with your own testing equipment, and I'm not sure if the procedures are the same or what, but immediately when I got your test results from last Thursday, maybe, I think, I directed Jason to look into it. He had the Health Department come over immediately and do their full testing, and the result is on my desk. They said everything was absolutely perfect, including the pH. I think it was 7.3 or 7.4.
Correct.
So I'm not sure, I don't know anything about the sodium carbonate, and you need to check that, Jason,
Absolutely.
and get an answer back very quickly. But I know that last week, after your check, the Health Department found very different results, and everything was in perfect line, and I will put a copy in your mailbox of that report.
The check that I did, Dennis, was strictly because you can't see the bottom of the pool, and if somebody goes down from where a lifeguard is sitting, they're not going to see it. And I did not do the check myself. I took it over to Larry's.
I think it might be an issue of the way that the information is collected. I'm not quite sure. I just know that the Health Department, which is the regulating agency, came over and did their test right after, not right after yours, but very quickly after yours. And I have the report, and everything was fine. The clarity issue, I don't know, and you're going to have to check into that, Jason, and get us some answers on that.
Hey, Larry, you have a comment?
Yes, I do. I think Commissioner Max Bauer's remarks to Jason are totally inappropriate for this forum here. Certainly, if every commissioner did what she did, we would, if I saw something that I didn't like in the physical plan, and Danny Brown was sitting up there, we'd waste commissioners' time discussing it. I think there are avenues, and I would suggest you use them, to report stuff like that. Certainly, we wouldn't allow a citizen to come up and sit there and address this board individually on the pool being cloudy. I think it's totally inappropriate.
Chris?
Obviously, Commissioner Fleece, I disagree with you. There have been consistent safety issues that I've seen that are concerns to me. I've seen students over there swimming in that pool with no lifeguard on deck.
Christine, that's your opinion, and, I respect your opinion.
I think this is not the
this is
forum for
wrong
an
forum.
argument between commissioners, and we can move on now, I believe. Thank you, Jason.
Thank you, Commissioner.
All right, let's move on to facilities.
Sodium carbonate, you just drink the water, it gets rid of your heartburn.
Good morning. Well, I guess we're going to revisit the exterior stairway.
I think
Don't need one.
Commissioner Inman had asked that we relook at this, so I asked Danny, and he's put together for you the history of this issue, including the various bids that we received for the different options that we talked about over time. And Danny's here to answer any questions you have, or we're here to take any direction that you'd like to give us.
Well, I guess I'll start. So we have not done anything since, we have not discussed this since August of 2000, or July of 2008, or August of 2008.
Good.
So if it would be the desire of the commission to get that corrected, what would you recommend how we proceed? Do we
Well,
go
excuse
back?
me, we talked about this in September of 2009. That's where this letter was sent to you. So we talked about it last September.
Okay, so if we want to correct the situation, how should we proceed?
Well, if you want me to rebid it, I'll do that.
You would have to tell us which way you wanted to rebid.
How would you like it rebid?
Remember, this was originally bid for replacing the walkways on both sides.
No, on
Both
on one
sides
side.
first?
Yes, on the north section.
Was it just the north section? I thought we were doing the whole thing the first time.
I think this is a bid just for the north side.
No, it was just the north section of that.
Okay. And then, well, then I'm confused.
Well, if you read the chronology here, you can see, let's see. Well, I'm sorry, you are correct. I'm even lost in this process now. We've been through it so many times. But yes, we were going to replace the whole stairway. Then it was recommended that,
Well, the lowest bid came in at $26,000,
that's correct.
and the board said that's too much money. We only had $20,000 budgeted.
Right.
And then we decided to reject those bids, and we came back with an alternate, and we suggested to you, well, maybe we just replace, because Dick brought it up and said, that's a big, huge stairway. We don't need all those stairs. So we said, well, maybe we replace just the half, and then turn the other half into, shrubbery and that kind of thing. And before I read into this, Danny, we did get bids on that, did we not?
That's correct.
And then the board said no to that, okay? And their reasoning was to make that kind of a physical change on those stairways when we know we have issues with the rest of the Boardman, the walkway, and that the
Retaining wall.
the parking lot and that kind of thing, the board was like, why would we do that piece until we study it all? Then we put the money in the budget, we requested the money to study the whole engineering thing, and then we pulled it out of the budget because of financial issues. So that's I think that's the history of it, Danny, right?
That's correct.
And what has changed? We haven't done anything with that whole,
We have done nothing with that, and in fact, now I think that the other set of stairs, I noticed the other day, are starting to deteriorate a little bit
Yes.
on the what would that be, the south
section.
stairs are now starting to deteriorate as well. Plus,
And
I
then-
agree with Commissioner Inman, I think it doesn't look good for 3 years of yellow tape across the stairway.
And in the meantime, we did cut the trees.
We did take the trees out.
So, and that was and we did that because of the fact that it was of the retaining wall. It was pushing the retaining wall out, so.
And I want to thank the board for doing that. I think that was a really good idea to get that out of there. I think that helped the situation considerably.
Right, Beth?
You said the south side stairs are now starting to deteriorate.
A little bit.
Is there any efficiency as far as the contractors you'll have out there and having them address those stairs at the same time you do the north side? Or are they really,
We're talking about the 2 sets of stairs, Commissioner, that have a railing right
Yep.
between them. Okay.
you're looking at the north side, putting in landscaping, but I imagine you're doing some concrete work along it or pulling that concrete out, correct?
We're not moving that.
We're not
right?
doing anything.
We're not doing anything.
Our second alternative that we brought back to the board was take out the north side and landscape it, and then redo the south side.
Okay, she means that
But
process.
we haven't done any of that because the board hasn't approved any of
I
that.
understand that.
Oh, okay.
My question is what you have here, your $14,000, that's just the north side for the landscaping, correct?
That's right.
That doesn't include addressing the south side stairs, which are starting to.
That's correct.
Yes,
be
that's right,
decrepit.
yes.
Okay, now, is there any reason, if we were to do the north side, is there any reason to address the concrete and the south side and those stairs at the same time? Is there any efficiency with these contractors?
Yes, there would be.
Okay, that's my question.
Yeah, I'm sorry, I didn't understand.
Now, do we have any money in the budget? Well, I was going to ask, do we have any money that we could use for the roughly $14,000 in this year? But I guess I would ask if we have any money for the $14,000 plus the south side stairs.
We don't have anything budgeted, do we, Danny?
No.
I think that the facilities fund has a fund balance, but I can't tell you, no, there's nothing appropriated, and I would have to go back to Dean to talk about where he could come up with money if in fact he can.
Okay, because I would be supportive if you can find the funds in the budget for this year to address the south side stairs that are starting to crumble and to do the landscaping on the north side. I would be supportive of you. If you can find that funding first, then to go rebid it, and we can do that.
Right, we have
Danny-
to rebid it, you're saying, right? Okay.
Danny, question for you. Do we, I haven't talked to you about the south side stairs where I saw that was starting to deteriorate. In the past, what we've done is our own guys have patched the stairs.
That's correct.
And it's held for a while. Have you looked at the south stairs recently? And, I mean,
Yeah.
is this something that we would patch, or is this something
No,
that
we would
would be
patch
better
it.
to have fixed through this process?
Well-
Bidding.
Here's actually what's happening.
Okay.
Since I've taped off that other section, obviously, we've been using the south side, which in the wintertime, in the past, we never have used the south section of that stairs. We never shoveled it. There was no need to do that, so we never salted it. Well, now we're starting to salt it. So in 2 years, you can see the results of the salt that's happened on the south section. That's really the problem, so.
So would your advice be that can be patched, or in your estimation, do we need to,
We need to change the whole stairs.
we would need to replace those
Yes.
stairs?
My suggestion, even at that, you had 27 feet of stairway, and you didn't even shovel half of it.
Right.
Now you're shoveling that half, and it's starting to deteriorate because that concrete's 35 years old.
Correct.
I say, instead of going in this direction, if you're gonna do something, I'd say to go in there with about an 8-foot stairway, which is plenty wide. You don't have that much traffic. Put about an 8-foot steel stairway in there, a graded stairway, and most of the time you don't even have to shovel it.
Is there any other
And
material
just
you can use?
switch to your kind of stairway that you're using. Put something in there that's non-skid.
That's one alternative, steel. He just
I
mentioned.
think it would be cheaper than pouring concrete.
It could be.
Okay, Larry has a comment.
Well, I think there's a couple issues here. One is that I think it's a little bit embarrassing that this thing's been taped off for 3 years and we haven't done anything. And, obviously, we've got a county that's got a AA Standard & Poor's bond rating, and we can't fix the stairs on the side of the building. I mean, I don't know how you answer that question to the public. And number two, I think it's a safety issue. Somebody starts going down there and hits a crumbling part of that stairs and falls, whether they should be on it or not, you're liable. And, from a safety issue, if somebody exiting from the lower level and trying to get up, and that's all taped off, that isn't good either. So I think that, we got to fix it. My feeling is we should go out for bid for both proposals, the whole stairway, or just half the stairway, and then we do the landscaping on it, and get those numbers, and I think, we're just it's either gonna have to come from the capital improvement fund, or it's gonna come from the fund balance, but I think we need to get it done. That's just
I
my
totally
personal
agree.
That's just my personal opinion.
All right,
Leave it
I'll
that
go
way.
Sonny, then Ross, then Larry.
Well, I guess, I tend to agree with Dick. We certainly don't need a 27-foot wide stairway there. I believe there's a multitude of options. There's some really high-tech type materials that can be used for stairways in today's world, everything from fiberglass to grip strut to, concrete. Concrete pans. Concrete pans don't work real well in our part of the country because of the salt problem that you talked about earlier. But I think the thing that's real obvious down there is the fact that the concrete is deteriorated. The one half we knew was deteriorated. The other half was marginal at best, and we had a long discussion about I didn't agree with the way it was bid out and that we were going to reuse the railings and those kind of things because they don't comply with the current codes. But that's neither here nor there. The fact remains that we do not need more than a 8 to 12 foot wide stairway. So my suggestion would be is we have someone design an 8 to 12 foot wide stairway to put down that thing and deal with what we do with the vacated space and come back with some sort of a proposal for that. And then we look about where we can find the money, But I would ask that you look at alternatives to concrete. Concrete does not handle salt well.
No.
It just doesn't. And in our part of the country, in a public stairway where you have to keep it shoveled and salted very heavily, and the only other option we would have would be to heat it. And that is an alternative for us, and we have that capability. That's the only way that concrete works in our part of the country, is to heat it.
Okay, Ross?
Is the county totally on the hook for the exterior of the governmental center? I mean, we don't get any money back from the city?
The city pays a percentage of whatever our capital projects are.
Okay, so that we could get some money from the city for this?
I believe so.
Hey, Larry?
We should plant poison ivy.
On both sides.
It takes very little water, and it tends to keep people out of there.
See, I thought he was going to suggest forget the stairway and give everybody sleds, but,
I would
It'd be more
agree with
fun.
Dick.
Have to put a ladder into the river because they're all going to be having to climb back out.
I would agree with Dick. I think we need a 8-foot stairway on the north side from where the present north stairs are, and then take the remaining and landscape it. And I agree with what Sonny said. We ought to look at some different materials or put a cement one in there and heat it, you know.
One thing that we have to be careful of, and Commissioner Wheelock brought this to my attention just now, one of our concerns always was, there used to be a pathway, a stair, way on the south side of our property that went down to the river, and it deteriorated and came out, and so one thing we'll have to check is when we do some modification on the north end, does that impact the ADA issues on the south end? And Danny, one of the things I want you to look into is, could our guys build a rampway on that south end the way they did on the other side of the river to, allow handicapped people down to the river? So you probably have looked at it already, but I want to talk about that.
We certainly could, but anything that we do out there is going to fall under the ADA, the handicap situation. And I'm afraid if we go out there and start building something, somebody's going to question us about the ADA rules.
We need to talk to Michaela from
Well, you
the
gotta know
city.
what you're gonna do with the whole thing.
Yeah, we
That's
need to
correct.
talk to Michaela from the city, because, like if someone, here's the problem. People with a handicap could access it during work hours through the building and the elevator.
They can. Right.
But they can't access it
That's correct.
after hours, the river bottom, now, we built it, at a time when we did not have to meet those requirements, so we're going to have to check that as well. But, so you'd like us to come back with a proposal, a concept that would, give you some idea of what we might go out and bid, and then we could, and then we'll see if you want us to take it out.
Okay, we have consensus on that?
Can you bring that back in a month from now?
Yes, I think. Can we, Dan?
Well, first of all, I'm not clear yet as to what I'm going to do.
You're going to go back,
So
and
you gotta-
we're going to go talk to an architect, and we're going to try to design
All
something
right, we're going
that's
to
about
spend
an
some money on an
8-foot,
architect.
about an 8-foot stairway, looking at alternatives to concrete, landscaping the remainder of that property, that stairway. Correct?
And also, you're going to identify some funds.
Yeah, I'll do that too at the same time. Not poison ivy.
From my perspective, if it'll help, I'm more than willing to help give you some suggestions of different alternative materials that you can look at.
Okay,
And
sure.
some of the architects in town are much better at those alternatives than others, so, we can talk about that, just.
Okay.
Chris?
Because there's a lot of options.
sorry.
There are a lot of options available to us that weren't available 35 years ago.
Right.
But there are restrictions on it. Dick talked about the grading steps that you didn't have to shovel. We used to build a lot of stairways out of bar grading. They had 1-inch by 4-inch holes, so everything drops through them. It's not an issue. But in today's world, the hole cannot be more than a quarter of an inch. The riser, the little nipples have to be only so high. There's all kinds of requirements because some lady in her stilettos might be walking down this egress stairway and her spike goes through the hole.
That'd be fun to watch.
Could be.
All right, Chris?
I ask this question every time this topic comes up, and I'm going to continue to ask this question. Can't we just take those out and plant it?
You gotta go down. You
You
gotta
have to have
go.
an egress from that lower stairway.
I will check again,
But you can walk along the river.
but you can't get up,
But we don't have anything at the other end either.
You can
That's
walk all
that
the way
stairway
around the
we have to
building,
take
too.
out.
You got that lower
But I will double check that again to make absolutely sure.
You should have a catapult.
Okay, so we're moving forward with the plan.
I think we have an idea, and we'll do our best to get it back next month.
All right, thank you, Danny.
Thank you.
All right, let's move on to Human Resources, Brownfield Office Specialist position. Page 102.
Pull up some chairs.
Okay.
Good morning, John Syke, Grand Traverse County Planning Director.
Good morning, Jen Seaman, Human Resources Director, Grand Traverse County. Anita?
Yeah.
We are here today to talk about the office specialist position and in the Planning and Development Department. Currently staffed at 37.5 hours per week, and we are looking to increase that position to 40 hours per week. You want to talk about funding?
Sure. The funding for this position currently comes from half of the land bank and half from the brownfield program, and that the increase up to 40 hours would continue that split of funding, so it does not take from any general fund dollars. If I could just mention kind of really the basis for this request is that one of the things that the planning department has done since I've arrived here is it's taken on the land bank, the EDC, and the Brownfield Authority. And the staffing for those, while we've taken them on, really hasn't changed a whole lot, but certainly the application of those programs and those tools have. I think the county's often spent a lot of its resources on planning and recognizes the importance of planning. Well, the other three programs, the EDC, the Brownfield Authority, the Land Bank, are really implementation of a lot of our plans for the county. And since we don't have county zoning in Grand Traverse County, it's one of the key tools for us to help direct development in the places that we want it to occur. And those programs have been very successful. One thing we have to recognize is when a lot of the projects that our department takes on, they don't go away. As the Brownfield program grows, each additional project that comes on stays with us because these are long-term projects. There's tax increment financing that goes on for several years. So it's not like we go from one project to the next. We keep amassing. So the demand for staffing continues to increase, and this is one effort to really help support those particular programs.
Sonny.
Mr. Chairman, I would move to approve the expansion of the office specialist in the Brownfield redevelopment program from 37 and a half hours to 40 hours per week.
Support.
And any further discussion? Larry, did you have a question? Or?
I was going to make the motion.
Okay. All
That's
right.
the only person, isn't that the only other staff member in your office? There's Jean and then this person, is that right?
Well, this is Karen McIntyre, who's assistant to Jean. We also have Midge Werner in our office. There's 4 of us total.
Okay.
All right, Sonny.
Yeah, I guess the one thing that, I won't, John kind of alluded to it a little bit, but maybe I can expand on it a little bit. One of the things that we found that we can do a lot with our land bank and our brownfield and the land bank that I sit on is we've been meeting regularly with the not-for-profits, Habitat for Humanity, Homestretch, those people about providing affordable housing in our community and using the land bank as a tool. We've also now started meeting with the townships about using the land bank in their communities where they can get developments done. Long Lake Township, for example, is looking at a town center that the developer, in order to get this project off the ground, he needs a little bit of a break to help him do that. So we're having discussions with them about the land bank actually holding a portion of that property while the development's done, and therefore deferring the taxes for it, and possibly they can make this thing happen. And they've got a lot of players in there. They have a for-profit developer, which is going to be a philosophy change for us if we're going to deal with a for-profit developer, because we've never done that before. So we have to look at that, whether it's something we still want to do. You've got the townships, you've got TCAPS has agreed to turn the new Long Lake Elementary School 90 degrees instead of facing North Long Lake Road, facing this town center when they construct the new school next year. So, they've got a lot of key players here, and it's important that we note that the county is a part of that process, and that takes time. And a couple hours a week doesn't seem like a lot, but a lot can be done in a couple hours a week if you're moving in the right direction.
Okay, Dennis?
I support this as well, but I did want to point out to the commissioners that this is kind of an initial indication of a bigger issue that we have to deal with the staffing in this department if we're going to continue to do the same things. This issue, John and I have talked about this issue of this housing trust fund development and things like that. These things are kind of coming fast and furious, these new programs and new responsibilities being put on the planning and development department, and it's now becoming, EDC, Brownfield, land bank, housing.
Solid waste.
And we're starting to get concerned that staff can't continue to handle this increased load. And so I just wanted you to be aware that's an issue, and it's a reality that we're facing. I mean, John and I have talked about, how much can we really do with a housing trust fund program? The community, we think, is going to really want it, but it's going to require a good deal of staffing to take it on. So just, that's for later, but I wanted you to be aware. This is kind of an initial indicator of that.
I'd also like to mention, if you want to see some tangible things that are happening with the brownfield, downtown Traverse City, you have 101 Park Street, you have Division in Front Street, you have the parking deck, you have the Commons that is just booming. There are a lot of tangible things that are happening with the brownfield, and it's definitely growing, and it's doing great work in this city. And I don't think you look around in Michigan, you'll see many things growing like Traverse City is right now. Okay, we have a motion. And any further discussion? Okay, let's vote on approve a request to increase the specialist position in brownfield redevelopment from 3.75 hours per week to 40 hours per week, a 1.0 FTE, and for the staffing plan to amend accordingly. All those in favor say aye.
Aye.
Opposed, the same. Motion carries. Thank you.
Thank you.
All right.
Jen, stick around for
John?
this next issue, okay?
Or Jen?
If you would, please.
We have the DPW now. The additional compensation, 103.
Good morning. The item on your agenda has been approved by both the Sewer and Water and the Board of Public Works, and that's the recommendation to compensate Diane for additional time that was worked. There were 2 vacancies in the office, and with Chris gone and myself, I think we put a lot more strain on her at the time, and we added additional meetings with the Septic Treatment Finance Committee and as well as the G5 later on, so that we are back to a normal working period for her, and we're asking that this be approved.
Okay,
Move for approval.
Support.
We have motion and support. Any further questions? Ross?
So Diane is an exempt employee and as such not eligible for overtime?
Correct, yes.
Is that the deal? Okay, but she has put in these additional hours?
Yes, there's a tabulation in there, and I can verify that because I was asking her to keep track of the time because I knew there were a lot of times that she was in there on the weekend at different times. So.
Okay, and what were Glenn Lyle's objections?
Glenn felt that the townships have no say in the compensation period, that it's strictly their county employees, therefore he voted no.
And I requested that Ross take this back and get approval from the Sewer and Water and the 5 townships because they're paying the bill on this. So that's why I wanted it to go back to them to make sure they were aware that this extra cost would be paid out of their funds. And
even though technically they don't have a say in it?
That's correct. I just did it out of, kind of a courtesy to them.
And Beth?
I'm looking at the Excel spreadsheet that you have on page 105, and this is the extra hours on a daily basis through these months?
That's the total time, those are the times that she spent, and those were tabulated, and we rechecked those, and actually I have been working with her to get comp time so that she's back in the balance so that she complies with the county policies.
So, because I see negative numbers here, so were
No,
those when
those
she
were
took
taken
2
into-
hours off, like comp time?
Yep.
So she did have the ability, when she was working extra, to take that as comp time at different times?
Some, but very little. As you look at it, as I say, we were short 2 employees, then we brought Ann on board, and then later on, we filled the second one and brought Cindy.
Okay, when were those filled?
Well, they were vacant for, one was vacant for about 4 months, I think, and the other one about 3. We had an employee that was there and then left right when we hired Ann. She'd been there for a little over a year, I think.
So the 2, because when were the 2 that were vacant, when were those positions hired?
Well, I'd have to go back in the records on that, Beth. I know they were 1 in the spring and 1 in early summer, I think.
Okay.
I want to add that the reason that I was willing to bring this to the board for consideration is that last time is related to the extra work that she does related to Chris being gone that Ross doesn't do on a part-time basis. She takes over some of that.
That was my second question. I had
Yeah.
another question.
Oh, I'm
and
sorry.
That was exactly it.
Oh.
Was what specifically did Chris do that she took over?
Could you talk about that?
I have systematically allocated more work to all of the employees that doesn't need to come across my desk. And that's been part of the issue that both George and Diane have both taken on more duties. And what Dennis was saying, the last time Chris was away, we did an adjustment in their total compensation package for the two at that time. And this time it was worse because of the vacancies. It was only on Diane, so we're not asking for any adjustment on George. But they both have assumed more duties and responsibilities as far as I'm concerned, so that they're not going across the desk of the acting director.
I think last time, and I can't remember which was which, one was compensated, this board approved an additional $500, and the other one was $750, I believe. And they were both compensated. In that case, when they left, when Chris left, they did it kind of at the beginning, and they came back, which is the appropriate way, and said, these people are going to be taking on additional responsibility, and the board said, okay, you'll be compensated extra for it. In this case, it fell through the cracks when Ross came on, and then Ross looked at it and said, wait a minute, we didn't do anything to deal with this, and came to me. So this is kind of a resolution of that. And so from the standpoint of compensating extra for the additional duties, this is consistent in that. It's not consistent in the fact that it came after the fact as opposed to before, the way it should have. But Ross, I don't think you answered Beth's question. What kind of things is she doing?
Well, there's a lot of things that we're doing, for instance, on bankruptcies. And right now, we're dealing with a bankruptcy on Manitou Woods. It's about $38,000 delinquent. And that's being handled by staff in the office, not by me. We set up a procedure, went through legal counsel, have 2 standard letters that we send out on every bankruptcy that comes in now, and that protects us. And the only problem we have the right to put it on the tax bill, but anything that falls between the 6-month delinquent and that time, we can lose. And general growth is another one. Those are huge tax bills. And so a lot of items like that were coming in, and the paperwork was there, but it was never being handled. So a number of those, we've set up procedures internally within the department to take care of that so that we're protected.
Well, another thing is we added the G5 committee, and she's staffing the G5 committee as well. So
And that's, as I had the other recommendation last June to eliminate sewer and water, and then later on I've recommended we eliminate G5. Those both have a cost of a little over $20,000 a year. And I'd like to see them both removed.
You mentioned that you spread some of the work over other employees as well, and you mentioned administratively you've done that. And the other employees are hourly, so they have the opportunity to?
Mm-hmm. And Diane has done a good job of training and supervising those people on additional duties that we've done.
So what does the 8 days equate to financially?
I don't have a calculation of what this came up to. Oh, financially?
Thought it was in there someplace.
I don't have that number.
We did have that number at the DPW meeting. I don't recall it, Beth.
Roughly?
Go to Jen.
We could go figure it out, Commissioners, if you want us to do that. Jen can
I
check it
would
for
guess
us.
it's between $1,500 and $1,800. That's my guess, but I'm not sure.
No, for 8 days?
By the time you get it, you have to look at it, that if you're compensating, you got to adjust for the other benefits that go in there that are retirement and different things that we have to
Commissioner,
pay.
if you'd like, we could
get the
just not
figure.
take action on this, and Jen could go check the number and tell you what 8 days cost, and then come back to it, if that's helpful to you.
Mr. Chairman,
Larry?
I'm prepared to make a motion based on the recommendation of Mr.
We have a motion.
I thought we have a motion.
Yes, made by Richardson, supported by Wheelock.
I guess
For this compensation.
I guess my comment would be,
Thomas, yeah, sorry.
Let's
Richard
have the dollar amount at the Board of Commissioners meeting. This is a recommendation committee. The final vote will be done at the end of the month.
That's fine.
So, but we need to remember that first and foremost, this isn't our money. This is sewer and water and DPW money. It's provided by those 5 townships.
Okay, Ross?
My comment is related but not specifically this issue, and Dennis, I really think that we need a full-time DPW director,
Well, I agree with you, Commissioner.
whether it's temporary or acting or whatever, and nothing against Ross Child, because obviously he's been filling in, but I don't think it's been fair to him to, the job is too important to, it's been a year and 2 or 3 months now.
Commissioner, I agree with you, and we now think it'll be through next April at least.
And then you need to hire somebody on a full-time basis and then deal with the issues if, the...
Actually,
I believe
I
that
raised
Sewer
that
and
at
Water
G-
is of the same opinion.
I raised that issue at G5, and I think
Then I'm supporting it then.
Well, let me update you. At the, I agree with that, and so I had I had several meetings now with the chairman of G5 and the chairman of Sewer and Water, and then this last time with those two and also the chairman of the Board of Public Works. And I offered them that option, let's hire a director. They decided that they preferred not to hire a director, but instead to hire an engineering firm. Initially, my understanding was to manage the operation and to handle specific engineering work. And they appointed Chuck Horn to kind of work through all that, the chairman of the BPW, with Ross, and he's been working with Ross. And my understanding now is that may have been modified by Chuck, and he now wants to hire someone to do specific engineering projects, but not necessarily somebody to manage the operation.
There's two things. The engineering projects have been split off, and there are 18 of those. Those have been assigned to Wade Trim under the contract for the engineer of record. The other one is the total review of the operation and that of the Public Works operation, and they're negotiating with an individual from Wade Trim to do that study, and that's separate. But the day-to-day management in the office and that, they were going to leave with me. And I'm trying to schedule a meeting with Dennis after we got the latest note. I'd like to meet with Dennis because we'll maybe look at some other options.
So the situation is, the townships have indicated, not through official action, but through their leadership, that they prefer to use an engineering firm to take up some of this slack as opposed to hiring a director. And I told them I was willing to go whichever way they preferred, but I really thought hiring somebody full-time is what we needed. So that's the situation. I'd be more than happy to convey to them that you think we should hire a full-time director. They, I think, want to go the other way. Now, I don't know whether that's all of them, but that's the leadership of the G5 that feel they want to go this other way. And so I'm glad to take back any suggestions, but I would want to talk to them again before I hired a director, because that's not kind of the way they are saying they want to go.
Okay, I believe we're digressing here. We have a motion on the floor. I would like to vote on that, and I'd like to make clear this is a one-time compensation.
Yes.
Yep. And so all those in favor say aye.
Could you restate the motion, please?
Oh, okay, the motion
One in
is
the room.
to compensate Diane Thompson for 8 days of work. Correct?
Yes.
All right. All right. Is that clear for everybody?
Monetarily?
Monetarily, well, all benefits.
Yeah, we're bringing the number, we don't have the number here, we're bringing it to the board meeting before you take final action.
And what about the 8 compensatory?
The compensatory time is being handled, and we're doing that internally, and we've been doing that. After we got the 2 employees, we began to back off and try and get some of this, so it was taken care of.
Thank you.
Yeah.
Oh, wait a second. I guess I'm not clear. You're doing 8 comp days as well
There were a total of 16 days, and I didn't want to pay for 16. I said, we'd like to work on it, because the other thing that Diane needed really was she had a medical leave last year, and she also needs some time off. So I said, I would like to do it with 8 and 8, rather than pay the compensation for the 16.
We're just dealing with the 8 right now.
That's right. That's the only thing that's dealing there, yeah.
No, I don't think so. I think they would have to approve the comp days as well.
We have to approve both, but the financial implications to us is strictly the
days paid.
The days paid, and it truly is not our money even then.
And the motion is just for the 8 days right now.
Correct.
Well, I think if that's the motion, it should be amended, because it should really say that you recognize the 8 comp days as well. because it's part of compensation. It'll be moved over to this year. She'll be able to take that time off, and so I think it's important that both of those be in there.
So
Now,
we
you
need
can
eight,
take-
Just to get me home in time for supper, I will amend it to include the 8 comp days.
okay, Sonny?
If I support it, that's fine.
So 8 comp days and 8 regular days, a total of 16 days. Ross?
I mean, I'm not opposed to the 8 comp days, but really, this is something we have to approve?
Well, here's the thing. There is a regular policy in place for how comp days are collected, okay? This is after the fact. So I can't tell you absolutely that you need to approve the comp days, but but you're the highest authority, and so I'd rather have you say yes, and then I know we're covered.
Well, I think the other unique piece of this is like another department that we have that I'm familiar with. This is a county employee who's under the direct management, if you will, by the 5 townships. No, but she's still a county employee.
No, she's under the management of Dennis Alea.
DPW. Okay, we have a motion, 8 comp days, 8 regular days. The totals for those compensations will be brought to us at the end of the month. And we have the motion. All those in favor say aye. Aye. Opposed, the same? Okay, motion carries.
Okay, the next item is the 2% grant applications, and you approved the process for doing this. Now it's a matter of determining whether you want to do that by committee to review the 2% applications, or whether you want the whole board to review the 2% applications as RMA. And so we just need some direction from you on how you want to do that. Do you want to appoint a committee that will sit down and interview these applicants, thank you, or do you want to do it, all of you, at a regular meeting or a special meeting?
I'd like to appoint a committee.
Okay.
You usually have, what, at least
We have consensus on that?
And you're not going to be on it, right?
In the letter, it states that over the last 5 years, there have been about 16 on average.
Ross?
Is it necessary that we formally interview each applicant? Is it possible that we could have a meeting and have the applicants on hand and then have them available for questions if there are questions?
It is. It's also possible that we could collect your questions and get those to the applicants, as long as it's done in a timely manner, and get you back written answers to your questions, and then you just have all that and make your decisions. You don't have to interview them. That's up to you.
Good.
All right, so we need a motion to form a committee, or?
Mr. Chairman, I would move to appoint a 4-commissioner committee to review 2% applications.
Support. You have a motion and support. Any further discussion? Sonny?
I guess the point is these people that are making these applications want to make a presentation to you about what the merits of their program are. And I believe you have to give them that opportunity. You know, I'm not sure that we can sit here with this body, with what we have on our plate to do, and do it in a day, but I think we have to give them the opportunity. You know, I appreciate the fact that the tribe has finally given us an ability by which we can rank which programs we believe have merit, in which we've never had that before, and that's why we've always consistently just rubber stamped them and sent them all without any comments one way or the other. You know, I'm hoping that through this process, yes, we will probably continue to send all of the applications to the tribe, but I believe we will set a priority by which we believe the programs benefit the community as a whole the most. And I think that's what we should be doing with this process. And even though I have a full plate, I will be volunteering to sit on that committee because I believe it has a lot of merit to rank these programs and try to determine which have the most value to the community as a whole.
Okay, any further discussion?
That's probably what everyone was thinking when you...
Well, I figured that.
All right, any further discussion? We have a motion on the floor to support a 4-member steering committee, so to speak. All those in favor say aye.
Was there a second to that?
Yeah.
I seconded.
Oh, I'm sorry.
Did you get that? Okay, all those in favor say aye.
Aye.
Opposed, the same? And now we have Sonny, who's volunteered. Anyone else who would like to serve on this
I
committee?
think Dick volunteered.
Dick volunteered?
Look at that. Chairman can't sit on that.
I'll do it.
All right, we got
Dick
Sonny,
rules.
and Chris seems to have volunteered.
You need one more?
Two more.
Two more.
I'll do it. Larry Inman. who's
One more.
Used to
One more.
dealing with it.
How about yourself?
I am very busy this time of year.
Oh, that's right, cherries.
When is it again? It's
How
in-
about making a 3-member committee out of it?
That's fine.
That's-
That's fine. I'll do it.
Beth? Okay.
Thank you, Commissioners.
Now, who we got?
Sonny.
Beth and Chris and then Larry and I.
Yep.
Great, thank you.
Okay.
Okay,
Only
septic,
if Dick will attend in my absence if I can't make it.
There you go. That's a deal.
septic treatment cash advance.
Right, something simple.
Well, the information is just been provided to you. We expect that it'll be, around the $125,000 range for the May payment. This would be the first time that that we were not able to make a May payment. And I've provided for you 3 options, but, there may be other options that you want to consider as well.
Larry.
Well, given that we're still in the process of working with the 5 guaranteeing townships and the Septage Finance Committee, which is meeting on a regular basis, I would be supportive of continuing our gesture to allow them to have an advance if they're short up to the May payment, without interest. So if you're looking for a dollar amount, I would just say up to $200,000 for the May payment.
Are you making a motion for discussion?
Yes. So I would make that motion.
Support.
All right, we have a motion of support. Ross? Okay, let me just restate the motion. We have a motion to essentially provide the short-term cash advance at no interest.
Up to $200,000.
Option number 1.
Well, $150,000,
Is that all?
Yeah, it's not
Okay,
more than
up to
that.
$150,000.
150,000. Okay, option number 1 at 150,000. All right, now Ross.
I absolutely won't vote for this. It's, we might as well just say we own the plant and, start funding it. You've had one of the township supervisors of the G5 last Friday suggested that we should continue to loan the money for 4 years. They have no source of income to repay the money, so why would we continue to loan the money? As long as we loan the money, no one is going to get, serious about what we need to do with this plant, how we're going to fund it, or maybe the smartest thing is to just mothball it, or maybe just knock it down. But the point is that, when you loan somebody money, it's because there's an expectation or there is a source of repayment, and there is no source of repayment.
Chris?
Well, I would echo Commissioner Richardson's words. That plant isn't just bleeding, it's hemorrhaging. And if we continue to provide short-term advances to finance that with no interest, look how long they have been discussing financial options to make that plant viable, and nothing has been done. And I don't believe anything is going to be done until we stop. This is the payment, the bond payment, that is interest only. What happens in November, folks? We have got to get them to move, and this is not the way to get them to move.
Larry?
I might agree with Ross on one thing. I think it's time, and we talked about it, we got 5 resolutions from the Guaranteeing Townships over a year ago now, and I think it's time that we see if they are still interested in the resolutions they provided to the board, and we relieve them of their financial obligations, and the county takes over the plant, and we run the plant. To demolish it or to mothball it, really disagree with that. Why would we want to dirty our watershed in Grand Traverse County over money? It's not worth it when we have the wherewithal to take care of it. I think that plant can be viable in the future. I think it should have been owned by the county to begin with. The county should have stepped up to the plate at the time. They didn't. We have 5 townships we can thank that did. I think it's time for us to let them go and for us to take it over. And I think you would see the attitudes of the people in the rural townships change considerably, being it's owned as a county entity then.
Okay, Dick.
I've been thinking about this idea of closing the plant for a period of time, but I'm just afraid that if we did close it until things got better, that you would never see it open again. The only possibility there is to sell it to a private outfit and let them run it.
All right, Sonny?
Well, I guess I'm very concerned about any discussion about closing the plant because I believe that there are haulers and entities out here and public citizens and that are expecting to have a place to get rid of this material, and the plant is the only one that has. You know, we also have to remember that there's a state law in place that says that it has to go to a plant. You know, you can't just dump it underground anymore. And I think, what is it, 2013, there's the next round of restriction.
2010, it goes to the 25-mile radius, but I think the other thing is there are some outlets for, like up in Antrim County and over in Leelanau County, where they can put in a 50,000 gallon tank and go until 2025.
But the point is, treating the septic is still the right thing to do. This is the plant we have. You know, I absolutely believe in the plant. I'm more than willing to agree with Larry and have a discussion about whether the county should own this plant. That being said, you know, I said a year ago, I either want to see a real viable financial plan by the responsible townships, or at least a commitment by them for funds out of their budget to help meet this need, or else I won't support another loan. I said that a year ago, and I will still stand by that. I don't believe that the 5 townships, 6 townships, however you want to call it, have done a viable financial plan of how they're going to operate this program, and they are not committing any of their funds to fix it. You know, even when we wanted to do the study, the financial study that was being done, they wanted all of that money to come out of the funds that the septic plant had. They were not willing to commit one dime of their township funds. So why can they sit here and say they will not commit a dime of township funds, but they're expecting the county to commit our funds because we're not on the hook for this? They are. Ross?
I too believe the fact of the septic plant is a good thing, but my question is, how are you going to pay for it? Because every time it comes around, you folks who were here when this thing happened, you say, oh, it's a good thing, it's a great thing, but don't expect those people with septic tanks out in the rural townships to have to pay any money for it. You know, the 12 cents a gallon should do it. Well, the 12 cents a gallon doesn't do it. We're going to be $600,000 plus short this year. It's going to be pushing $1 million by next year. This is every year. So just tell me how you're going to pay for it. I'm all for the plant, but just tell me who's going to pay for it. And don't tell me that people who have sewers are going to pay for it, because we're already putting our cash in the pot to make the water clean.
Chris?
Someone needs to explain to me what's wrong with asking the townships. I mean, the county's already got $105,000 into it as an interest-free loan. What's wrong with those townships being asked to step up and pay $125,000 to $150,000 as a loan to the plant? Let's get the financial problem with that plant solved. It's not going to be solved if we continue to step up to the plate. And I would like to ask, I mean, I've heard commissioners say that they are against special assessments. How are we going to pay for it? We don't have that kind of money. I'm just totally opposed to this motion.
Larry?
Well, I see this motion as a short-term interim advance and not a progression of a longer-term commitment on our part in terms of larger dollars that would be advanced over a longer period of time. I think that the feeling I'm getting from members of the 5 townships and also the Finance Committee, Septage Finance Committee, is that we recognize that with the absence of Bay Harbor, we're going to have to accelerate our decision. We're going to have to make some hard decisions relatively soon. And I think that we have a feeling and a commitment from the Septage Finance Committee that, you know, they're going to meet on a very, very regular basis, and we're going to come to some conclusions fairly quickly because we know that that decision has to be made very soon, given you know, the Bay Harbor flow is going to cease fairly quickly, or has ceased. So I see this as just getting us through May or June, and I'm hopeful that we can make those hard decisions as a community and as a group during that time period.
Okay, well, Mike, did you have something to say?
Yeah, I guess this would be a temporary situation. The Septage Finance Committee still has a little more work to do. Let's let them finish their work. I see this as short-term, not the ultimate solution. Chris makes some good points, too, that need to be addressed eventually, but let's let the Septage Treatment Finance Committee finish its work.
Ross, you want to add something?
Yeah, the one thing, and those that were at the Septage Finance Subcommittee meeting and at the other meeting last week, the townships are actually taking this to their boards to ask the question about upfronting some money. And they said, and they did discuss this as a thing. This is a temporary thing because the payment is due May 1, and they said it'll get paid. Bill Wilkus will pay it because Bill pays everything on time no matter what. But they were asking if this would be a motion to do this at this time, and then they are addressing it. And we're going to ask them to address that at the townships. And I would like to tell you that I am going to try and force a decision within the next 30 to 60 days on behalf of the 5 townships, as well as the county, as well as the haulers, and as well as the out-county townships. So I'm not going to let it sit.
I would like to add something also to this. Is okay, there's been a certain amount of complacency probably with the townships because of COI, and that's been handled. In fact, it was on less than 2 months ago when the DPW was going to pay back the county that loan, and we'd be flush, and everything was break even up to this point. So it's not like, oh, this has been building and building, and now there's a problem. No, we thought we had a year, maybe 2 years of cash flow that would sustain the plant as it is. That's been dropped suddenly and unexpectedly, and now the complacency is, I believe, over, I hope, and people are now looking at this totally different, and there are different options coming to the table, and people, I believe, are looking at them more seriously. Whereas perhaps they were saying, we can put this off because we have this cash flow. That is not the point anymore. There are things that have changed dramatically, and I think people are taking it more serious and understand that there's a dramatic change and that there's cash flow problems have to be addressed. And I believe there's been some serious talk and some serious effort made. And to say that there's no money coming in to pay for this is mistaken. There is money, there's a cash flow, the plant is making money and generating money. It may not be making enough. And that's where I'd like to stop right now, and Dick has his hand up.
The only thing I was going to say is right from word go. We lost Bay Harbor. Well, I was always considered Bay Harbor a gift anyway. But right from word go, the idea always was there was going to be alternative sources like Cherry Blossom. However, they didn't have any, they ended up in bad shape. But that's one of the things we always worked on, was getting other sources, and they haven't come in. We had discussions with the landfill 3 years ago, and they could have been bringing that leachate over all these 3 years, but it was just they wanted to do it for nothing. So we got to work on these because the plant is made to take a lot of this stuff, and we got to have all the help we can get. but I think we have to go ahead.
Yeah, I'd like to also add that Ross is working very hard with other counties. As this radius expands, that we will be talking with Kalkaska, Wexford, Benzie, and Leelanau.
We have met with 5 counties now, there are 2 left, but I think, in listening to what's being said here today, I think we need to come and give you the same presentation that we're giving the other counties about the septic plant. The septic plant has processed 90 million gallons of waste over the 4.5 years. That's not gone on the ground. 90 million
Why
gallons.
don't you come up with a presentation that tells us how to pay for it, Ross?
I've got one of those too.
I don't want to hear about how it's done 90 million gallons. Why don't you explain how all your decisions, and the 3 of you who were here 7 years or 6 years ago, and people who continue to perpetuate this nonsense, you weren't willing to tell the people they had to pay for the plant 7 years ago, and you're not willing to tell them they have to pay for it now. Well, the county doesn't have the money to do this, and the county shouldn't have to have the money to pay for this. So, please, get real about it.
Okay, Ross?
Mr. Chairman, I would like to be real about it, and I'm saying, as of today, if you don't see a system put together within 30 to 60 days, I think you should take whatever action you want. But I think people need to make decisions. They've been avoiding them. It hasn't been on all on one side either. And a lot of the stuff that has come out on the out-county townships, I can't stand either. I wasn't part of the one that built it, but I can tell you right now, Mr. Richardson, if I wanted to, I would pay a special assessment. I'm on sewer. I would pay it to keep the water clean. I would promise that. And I'd like to see people come up and step up to the table and say, yes, we need it. 90 million gallons of waste on the land in this county is nothing that is good.
I agree with you completely.
Okay, then let's get a method to pay for it. I agree.
Okay, we have a motion on the floor. I'd like to call a motion, please.
I have a question. Dennis, is there any reason that we couldn't upfront half of the amount and have the 5 townships do the other half?
The decision that I'm asking you to make today is not related to what happens on May 1st. May 1st, we're paying this. We're not going to let this bond be in default. Your decision is what message you're going to tell the townships, and that is reimburse us. We'll loan it, reimburse us. We want you to pay it. You could say to them, we'll continue to loan, we made the initial, but you got to pay us back 50% of that, and you have to do the other half of the loan. So I just wanted to be clear. We're paying this. It's what you're going to tell the townships they need to do to take care of the issue of the action we take on May 1st. Am I clear?
I'm just wondering if that would send, like you said, it sends a message and perhaps looking at
That is an
partnership.
option. You could say, we fronted it, we expect you to give us half of it back and make a half of it up, yes.
And could you remind me again, what's the outstanding amount?
$105,000 right now. It was roughly $300,000 in November. They paid us back in December about $195,000 of it. And so it's about $105,000 that they still owe from last November's payment.
Ross?
The other thing that you need to know is that we have rebuilt the fund that they had taken before too, which was over $225,000. So that is back there, and the question that we addressed at the meeting, we could have used that money again to pay the bond. My recommendation is don't touch that. You're only putting off a bad decision.
That's the construction fund.
That's the construction
And really,
fund.
technically, that should not be used.
So that's been repaid and it's back in there.
Okay, I'm going to call a motion on the floor right now. That is option number 1, provide a short-term advance at no interest of $150,000 maximum.
I would make the motion to amend.
You can't make a motion to amend somebody else's motion.
I can make an amendment to the motion. I can move to amend the motion.
Yes, you can.
She
Yes,
can,
you
but it's got to be voted on.
Yeah.
She needs
Yes,
support.
gotta
So
vote on your
I
amendment.
would move that we amend the motion to obviously, make the bond payment, but that we provide the short-term advance at 50%, and we ask the guaranteeing townships to reimburse the other 50%. Support, anybody?
I believe it's died of lack of support.
Okay, let's go with
Okay, we have a motion for option number 1, a short-term advance at no interest of $150,000 maximum. And we need a roll call vote, please.
Commissioner Richardson?
No.
Thomas?
Yes.
Max Bauer?
No.
Fleece?
Yes.
Wheelock?
No.
Inman?
Yes.
Friend?
Yes.
Stepka?
Yes.
Chairman Hooper?
Yes.
6-3.
6-3, motion passes. Okay, I believe, thank you, Ross.
At the, next item is the BPW appointments. At the committee meeting, at one of the committee meetings, or I think it was Sewer and Water Committee, the townships reiterated again their request that you consider filling the 2 vacancies that you have on the Board of Public Works with Wayne Clatter and Rob Manigault, 2 of the township supervisors. Chris has put into your packet the names and applications that you have for 2 other individuals, Henry Huber and John Alishkar. And so you have designated a committee to do interviews for recommendations of appointment, but I wanted to bring the additional information to you that the 5 townships are reiterating their request for you to consider those 2 township supervisors to be added to the Board of Public Works.
Okay, Ross?
I would make a motion that if Wayne Clatter or Rob Manigault are interested in the vacant positions, that they should apply through the interview process and be interviewed with the other folks.
Support.
Okay, we have a motion and support. Any further discussion? I'm just concerned, how long is this going to take?
Well, actually, I think, and I don't know why they're not in here, I was under the impression, in fact, I know I saw one, I think they both filled out applications.
Yeah, they did. They just would.
They have submitted applications.
So they are not in here, but the applications are done, so I would say as soon as the committee can meet, and I think the committee's been established, as soon as the committee can meet, they can make a recommendation to the board.
Okay, I would just encourage that committee to meet and get this moved on before the end of the month, if it's possible. Larry?
I'm wondering why we would interview 2 elected officials, supervisors of the township, to represent a constituency that obviously have a very vested interest in this matter. Why would we subject them to come in front of us and be interviewed? I can see interviewing additional people, but to have Rob Manigault and Wayne Clatter come in front of an ad hoc board to be interviewed is crazy. Obviously, they're very interested, and they represent not just one person's opinion, they represent a whole lot of people's opinions, and they're elected officials. I don't think that we should subject them to that at all.
Hey, Beth?
I guess at this point in time, they would be interviewing because they would be up for the citizen position. I understand there's 2, the rural, and they would not fit that criteria, and so it would be for the citizen position. So they are not being appointed in their official capacity, but rather potentially as a citizen.
Doesn't make any difference. They're still elected officials. You can call it whatever you want, but black's black, white's white. If they're sitting there in a citizen's position, they're still representing their constituency, and they're there for an obvious reason.
Okay, Sonny?
Well, Larry, I'm not sure that I agree with that. I believe if they're asking this board to make them an appointment, they need to interview like every other citizen in this community, especially when I'm appointing them to a citizen position. And when they're sitting there voting as a citizen of Grand Traverse County, I would expect that they are looking at what's best for this community as a whole, not necessarily their personal entity that they're involved in. I have discussions all the time about the fact that members of boards need to represent what's best for the community as a whole. Now, if I am one of those Garrington townships and I'm voting whether I want to ask Grand Traverse County for the money instead of digging in my pocket to put it out there, am I representing what's best for the community as a whole, or am I representing what's best for me and my constituents? So I think it's important, as long as the only vacancy we have is a citizen vacancy, that those people interview. I do think that we need to encourage a change in the makeup of the Board of Public Works to allow those people, those Garrington townships, to have representation there. But I think there should be more rural representation there also. You know, I believe that all of those townships that are on the hook for the bill should have representation, but I believe that more rural townships need to have representation too. And I'm not exactly sure what legislation has to change in order to expand the Board of Public Works, but I believe if we're going to continue to use this Board of Public Works forum by which to manage this process, that we need to expand that board. And I don't know whether it's 13 people, 17 people, I have no idea. But I know that there's legislation in place that currently does not allow us to expand this board to get more representation.
Just on that issue, to kind of put that to bed, we've already worked on development of legislation that would take the number at your discretion up to, I believe, 15.
Up to 15.
And that is being talked to our legislators about it, and they're looking at it, and I think they're asking MAC to look at it as well, and the Township Association.
As the Michigan Townships Association.
I believe the tentative plan is to expand the BPW and eliminate sewer and water. Larry?
I guess it's my recollection that we postponed making the recommendation from Ross to add, with vacancies, the supervisors from the townships that have sewer and water, until we had a little more input from the townships at the Township County meeting at Twin Lakes. And from there, I thought we were going to come back and have a philosophy discussion at the board about what kind of makeup and what responsibilities do we want to have the Board of Public Works have. If it's just to the extent where we would like to have them manage their own sewer and water system and eliminate the G5 and eliminate sewer and water, then if that's the direction we felt we should be going in, we should be looking at in a direction of making those appointments. And then the discussion occurred, do they really want to have the authority, the responsibility and decision-making regarding other solid waste issues, or should we bring that back to perhaps another committee within the county? So I thought that before we moved forward with these appointments, this board was going to have a discussion about what is the makeup of the board, what are the roles and responsibilities, and then we would move forward with the appointments in one way or another. So that, I guess that's where I thought we were going. Did I miss something on this, or?
Yeah, because right now, when I'm on the subcommittee, when I go to look to appoint somebody, I'm going to do it under the current BPW configuration.
Right. I mean, I thought we were going to have a discussion about, are we going to change the makeup of the board and their roles and responsibilities, and then we were going to move forward with those appointments. I mean, should we have that discussion before we start interviewing?
I think last fall when we talked about it, when was it, December or whatever, there was no reason we couldn't have appointed at that. By the time you make the decision, you've had those vacancies there. I mean, there's no reason this committee can't fill under the current BPW configuration, and if we have the subsequent conversation and change things, then we alter the membership. There's no reason in the world. These people might serve 2 months. Guess what? At the speed of things, they might serve 2 years. Who knows?
Yeah,
but
2 years more likely.
Let's just get on with it and fill under the current BPW configuration, and then follow up with that.
And Larry, something to say?
Well, last fall, we did defer, LNA committee did defer making those appointments, because Larry is correct. So we could, this board, could study the makeup of the BPW and perhaps come up with a different situation. I agree with what Sonny said, but I question the validity of having interviews with people, number one being Rob Manigault, who has been in this process since day one, and having John Q. Citizen at large, whose expertise on this matter probably is very limited. I just wonder where the thought is there.
Well, I guess if I can comment, I'm not going to discount the qualifications of people that are in our community. So I'm going to interview them. I I could have, just because a person is an elected official, you know, and I don't want to talk about necessarily the two individuals. Just because a person is an elected official in any township in this community doesn't necessarily mean that they're qualified to set judgment on how we should operate a septic plant or how we should build a sewer system. You know, we could have qualified contracting engineers come in and apply for those positions, and I believe they would be more qualified than the elected official from, I don't know, take your pick, which township, you know?
I agree with what you're saying, but by the same token, we know who Wayne Clatter and Rob Manigold are. We know them, we know their qualifications, we know their interests. I'm not saying that we shouldn't interview the citizens. We absolutely should.
I'm not going to set a precedent that says just because you're an elected official, you don't have to apply to be appointed by this board.
Only in very few circumstances would I even say that, and this is one of those circumstances.
For the 15-minute interview it takes, they can come in and interview.
Okay, Ross?
Mr. Chairman, when they submitted the application, they intended to go through an interview process.
Exactly.
And they knew that.
Actually, they came to the meeting for
Yeah.
that purpose.
Yeah, I don't think there's any question that they expected to be interviewed, and I think that's part of it. They are at-large positions, they're not titled citizens, but they're at-large.
I think one issue that's come up is that just the length of time it's taken to come to this point, and that there is a certain amount of impatience on their part to figure out what's going on, and let's have this resolved. So I would like to move this. Larry?
Just one further clarification for Ross, that if the committee did end up appointing, let's just assume they did, the two supervisors, we would have a total of 4, not 5.
Yes.
Represented on the Board of Public Works.
That is correct.
So that would not represent a majority of them.
That is correct.
All right, okay.
But basically, we can't, because one's a rural position. One's rural position, correct?
Almost done.
Yeah, one's rural and one's a citizen at large.
So we
Yes,
we could,
one of these is a rural position.
yeah, so we couldn't actually do that hypothetically.
Okay, Mike, do you
I'm
have a
following you.
comment?
I'm following you, okay.
You know, last December, we did decide to hold off on this decision, but, you know, it's almost May now. I think Beth and Bruce are right. Let's move it forward, make the appointments, and if we change the configuration of the DPW, they sit for 2 months or 3 months or whatever, but let's fill them and move on.
Okay, I'm going to call a motion on the floor to, would you want to state it, Chris, please? Made the motion, didn't you? Oh, Ross did. Okay, Ross, would you restate it, please?
Well, I don't know, why don't you have Linda read it?
All right.
Commissioner Richardson moved that if Clatter and Manigold are interested, they should apply with the other applicants, and Commissioner Max Bauer seconded that.
So the motion is that,
They've already
well, they've already applied.
They've already applied.
I think it would be that you would go ahead with your interview process like you would normally do.
Yeah, that's basically what the
What
motion is.
I would prefer is a motion that gave the subcommittee direction to interview and place people in the BPW according to the current configuration.
Well, that's what you have to do, because we haven't changed the configuration.
Fine, okay.
And those are our rules.
And we have a great deal of faith in the 4 members on the
Well,
on the
here's what I don't
subcommittee
want to happen.
to do the job right.
I don't want to do that at the subcommittee level and then come back to the full board and then go, oh, you should have put the supervisor. So that's the direction.
Well, we'll
of the
either
consensus.
approve the recommendation or not, so.
Okay, we have a, Ross, one more.
The only point of clarification is that they will be informed, the supervisors, that they're being interviewed for an at-large position, not as a supervisor. And I think that's fair. That's your process. If you change the structure of the Board of Public Works when you can amend it, that's fine too. But somewhere along the line, we do need people. And I would love to have kept Scott Josiak, because just exactly as you were saying, he's an engineer who knew a lot of good things, so.
So we're clear on what the subcommittee's going to do? The applicants will be clear? The only thing that we're not clear on is how we're going to follow up on the process that Larry was talking about.
Oh, that's
a whole separate process.
We can
Right.
talk about that after we pass this motion.
Well, Ross is going to legislators and talking to them when things are happening in the background, NACO or MAC, blah, blah, blah. All right? We are now voting on the fact that these applicants, as all other applicants, will go through the application process and will be affirmed or denied in that process. All those in favor say aye.
Aye.
Opposed, the same? The motion carries.
I wanted to bring up one
quick item, just to let you know, remind you, the meeting on the issue with the school liaison officers will be next Monday at 2 p.m. here in the chamber. Initially, we were told that we would be meeting with just administrative staff from the TCAP schools, but now here's the list that I have as of yesterday. The superintendent will be there, the assistant superintendent and the finance director of the schools will be there. In addition, school board members Crandall, Hall, Rich, and Tank will be there. So there are 4 school board members so far that have said they will be at this meeting. And of course, we encourage all of you to be there, and Kingsley schools will be represented, and the sheriff and under sheriff and some of the staff. That's here, 2 o'clock, next Monday.
I have a quick question for you on that. Were the other 3 just unavailable schedule-wise, or?
I can't answer that. Initially, we were told that school board members were not going to attend and that it was going to be just maybe the president of the school board and staff. But since then, several others have signed up, and so I can't tell you why those other school board members are not here, but they were all invited, and they were told that the county board wanted to meet with the school board. My understanding was, at least initially, they did not want to have the school board meet with the county board, but evidently, some of them have had a change of heart because several of them are coming.
Chris?
Dennis, I attended the Traverse City Strategic Planning meeting Saturday morning, but I was only there for a couple of hours. And one of the things, because I had another meeting I had to go to, one of the things that they talked about was whether or not they should continue to fund the school liaison officer. I did not stay long enough to hear the outcome. Could you find out what the outcome of their discussion was?
Sure.
And any other unfinished business? Larry?
At a regularly scheduled meeting on the 31st, I had requested that on today's agenda, the septic plant be on the agenda so we could discuss the assessment, and I don't see it on there, and I'm wondering why.
I apologize, Commissioner. I guess we missed that. It was not intentional. You wanted to discuss the assessment?
Yeah, we were going to have, that was my request, that it be on the agenda so we could have a discussion regarding the septic plant and the assessment.
Put it on Ways and Means? Pardon? Put it on Ways and Means?
It may have been, it may be that I mistakenly told them to put it on Ways and Means, or I may have just missed it and not put it on here. My apology. We can do it either way. You can discuss it. Well, I guess if it's not on the agenda, you'd have to vote to discuss it. Or I can put it on Ways and Means next week.
I'd like to see it on Ways and Means then.
All right, that'd be great.
My apologies.
All right, now we have, let's go to the board rules.
Excuse me, I have one more thing if I could. I just want to
sorry.
mention. Afterwards, there's a picture over there, and there's a note that explains what it's for. We're asking each of the county commissioners, there's a Sharpie over there, to sign the matted area before you leave with just a little comment. It's a going away gift. So before you leave, if you would, just go over and put a signature on there. It's for one of our department heads that's retiring. And just, if you want to say a few words, please do. So I just wanted to remind you, please do that before you leave.
Hey, Dennis, regarding the school board meeting?
Yes.
Normally, I would say all 4 are coming, 3 can't obviously fit it in their schedule, and I know one of them that's the case, but specifically, I don't know with Kingsley who's coming or not coming, could we potentially just send a letter directly to those school board members and say, here's when the meeting's scheduled, we'd like to...
We'd like to encourage you to be there.
Right.
Yes, absolutely, we can do that. Would you like me to do that?
Yeah, that's fine.
Yeah, I'd be glad to do that.
I think more people that are there, this is obviously a very serious subject, so I think that's a great idea. And Dick?
Yeah, I just want to register concern about these meetings that are being scheduled between 1 and 5 in the afternoon. Yesterday was a good example. We had 2 people missing because it's not very convenient for them to come in the afternoon because they're running businesses. And it's not convenient for me to drive in from the other time zone because it screwed my whole day up. And I would like to see these especially these special meetings, like with the school board and whoever, I'd either put them in the morning, I don't care, it's 8, 9 or so o'clock, but you've got to consider these people that have to take time away from their businesses.
So do them in the evening?
Evening is the perfect time.
Yeah, I'd prefer the evening.
I'd rather
That
come
works a
in
lot better for me.
I'd rather come in the evening,
So would I.
so,
Me too.
but you
There seems to be a
know,
general consensus on
2
that.
o'clock
We
just-
can pass that on to staff.
is really puts the screws to the whole day.
Well, I do know Katie works really hard on getting everybody together.
I think she
you know.
tries really hard
Yes.
to get a
Yeah.
certain
I will say,
time.
all I got
mean,
done yesterday, other than come in here, was I got 3 loads of laundry done.
I think
And I
one of the
hate doing
difficulties
that.
is we try to video all of our meetings, and this room is used on most nights, and that makes it difficult, but we will take that into consideration, we'll try to get that.
Just pretend there's no such thing as an afternoon.
Okay, now let's go on to B8. On page 50.
I pulled this off. I don't know if it's, my first thought was that we should reconvene the subcommittee that was formed to rewrite the rules. Maybe that's a little extreme, but mostly I just wanted,
Oh, no,
I just wanted to
that
run the
sounds like fun.
changes.
I don't know, let's
just
do
got done
that.
doing
That
that.
sounds like fun.
But I just wanted to run, just run it past the attorney. My memory is, and I'm not clear on this, but my memory is there was a reason that the order at the start of the meeting with the call to order and the invocation was the way it was. And I just wanted to, think we ought to consult with him before we change it all around.
Motion to send the recommendation to Bob Cooney for his
Support.
opinion.
What was the motion again?
Just to send the recommendation to Bob Cooney for his opinion, and bring back to this board.
Okay, we have a motion by Fran, support by Chris Maxwell, to move this,
To refer it.
Repeat.
To just take the recommendation to Bob Cooney
Take the
for his
recommendation.
opinion.
And then back to
And
RMA.
then bring back to this.
Next month. Okay, back to RMA next month. Bob Cooney first. All those in favor say aye.
Aye.
Opposed, the same. Okay, motion passes. Now, we have, any more new business? Another option for public comment. Seeing none. Commissioners' committee reports. Seeing none, let's go on to notices and/or announcements. Sonny?
Just a reminder, I will be out of town next week from Wednesday, so I won't be here for Ways and Means, and I'll be getting back in town the night of the 27th, so I will be here for the Board of Commissioners meeting, but I'll be unavailable at any time in between the two. If it's an emergency, you can call me out of my cell phone, and maybe Mickey Mouse will answer. I don't know, it's hard to say. Now, I received a notice yesterday in regard to looking at the video for the budgeting for outcomes. Is that still going to be available before the Board of Commissioners meeting on the 28th?
Yes.
Okay, because I can't make the other 2 dates.
Yeah, we were having a lot of difficulty finding a time when you all could get together, so we thought, well, let's try this instead. We'll have 3 different times, 3 times during the day, and also, I invited the department heads to come, and I said to them,
That's a good idea.
it'd be nice to come and sit with the commissioners and watch the video.
How long is the video?
90 minutes.
Oh. Okay, and that's what the emails were about? Making a time to see it and watch that? I thought it was something we could pick up and take home.
Nope, we're going to do it here, and we're going to video it here in this room. At a later date, we may be able to make it available once we've done this, but we want to get it to as many people as we can, and of course, I would encourage you all to
So I'm
try to
assuming that
make
it's
it.
going to be at 3 o'clock if our board meeting's at 5? Or no,
board meeting's at
our board
7.
meeting's at 7, so it's going to be at 5 o'clock.
Yeah, I believe that's the time that was on the list.
Yeah, it is. I was just thinking the board meeting was at 5.
Yeah.
And that's finalized now?
Yes, I think you should have all received that, or you will be.
Okay, 5 o'clock, next or last Wednesday of the month. Anything else? Notice and announcements?
Motion to adjourn.
Support? Or, I mean, whatever. Stand adjourned.
Please, everybody, sign that for me if you would. Larry, I apologize.